Students are joining. We will start in a minute. Hello, good morning, and welcome to Byju's Exam Prep. And we are in the middle of a discussion on the schedules of the Constitution. On 26 January 1950, there were 8 schedules. Later on, 4 more schedules were added. First Constitutional Amendment Act 1951, ninth schedule. 52nd Constitutional Amendment Act 1985, 10th schedule, which deals with anti-defection law, which we will discuss today. 11th and 12th schedules, these were added in 1992-93 by way of 73rd and 74th Amendment. 73rd Amendment deals with Panchayati Raj institutions. 74th Amendment deals with municipalities or urban local bodies. Schedule 1 talks about details of the states and union territories that we have, the names and territorial extent of all the 28 states and 8 union territories specified in the first schedule. Schedule 2 talks about the salaries, emoluments of president, vice president, speaker, judges, CAG, so on and so forth. Schedule 3, it talks about oath and affirmation. When oath or affirmation is administered to a minister, to a judge, to a CAG, all these are mentioned in the Schedule 3 of the Constitution. Then Schedule 4 talks about representation of states in the Rajya Sabha. All the 28 states that we have and 2 union territories that we have, they will have representation in the Rajya Sabha. And what is that representation? That is provided under Schedule 4 of the Constitution. Now let's look at Schedule 5 of the Constitution. And this is where we will talk about tribals, who were previously considered as aboriginals, original inhabitant of this country. Now, whether that theory is correct or incorrect, we don't have to get into that. One theory is known as the Aryan invasion theory. That means Aryans invaded India, which means Aryans came from outside. And when they came to India, there were the tribals already residing in India, aboriginals already residing in India, but because of the Aryan invasion, these individuals, original inhabitants of this country, they were pushed towards the forests. And then the Aryans invaded and captured the mainland India. There are a lot of sociologists, anthropologists who discredit this theory. But if we forget about the invasion part, just look at that, yes, these Aryans came from outside. Whether they invaded or not, that's a separate matter. Came from outside, but those who were originally residing this country, residing this land that becomes now India, they were pushed towards the forests. And these are different from the rest of the population. These are unique from the rest of the population. They have maintained their own culture, distinctiveness, their language, their script. Now, when you look at the colonial period, these tribals, we saw a lot of uprisings. Many a times in our history, these tribals, they rebelled against the colonial government, against the British government. And primary reason was money lending. These tribals, now the British would send its officers or non-tribals to these tribal areas, and they would give them money in the form of loan. But when this money they could not repay, their land was confiscated, and because of that, there was tribal uprisings. Not just that, these tribals would perform shifting agriculture. The entire land, and that is what we have discussed previously also, primitive communism. And that primitive communism, where the entire land does not belong to individuals but belongs to the community as a whole, this primitive communism was present in the tribal culture as well. The entire land belongs to the community as a whole. When this entire land belongs to the community as a whole, I am sowing some crops on a particular piece of land. After 2 years, 3 years, obviously the fertility of the soil would decrease. Then I would shift this pattern to another part of land, another portion of land, shifting agriculture, because the entire land belongs to me, belongs to the tribals. British imposed restrictions on shifting agriculture. That was another reason of tribal uprisings. And you would read that in modern history, even before 1857 revolt, there have been 70 to 90 instances of tribal uprisings. When the constitution was being written, the question arose, how do we deal with these tribals? Who are these tribals? Who are different from the people of the mainland India. J.S. Gure, one sociologist, he referred to tribals as backward Hindus, basically called them backward. But they're not backward, they're unique, they're different. In fact, in some ways, their practices are more liberal than the practices of the mainland India. So don't call them backward, call them unique, different from the rest of the people who are residing and inhabiting the mainland India. Now, the question was, how do we deal with them? Because they have their own culture, unique culture, different practices. And we have discussed some of the tribal practices when we discuss Uniform Civil Code. Pandit Nehru, and he had an advisor, Verrier Elvin. Together they decided that we should have some constitutional safeguards for these tribals. Pandit Nehru's position was, we should not make these tribals second-rate copy of ourselves. Let them decide how they want to develop, what is the pace of development that they wish to pursue. We should not impose our own idea of development on them. So some sort of isolation was practiced. One option was complete integration. Tribal culture disappears. Tribals and non-tribals, they are one, and we will have one common laws for the entire country. But that would not be respecting the diversity, because we are a country of diversity. That is why some policy of isolation was practiced vis-a-vis these tribals. So for these tribals, they should be able to maintain their own culture, own distinctiveness. And that is how constitutional safeguards were provided in the form of Schedule 5, in the form of Schedule 6 of the Constitution. Schedule 5 talks about and looks at that there is a significant tribal population. We will administer those as scheduled tribal areas. But these should be states other than Assam, Meghalaya, Mizoram, and Tripura. Why? Because these 4 states are exclusively dealt under Schedule 6 of the Constitution. Sir, what are you saying? I am talking about tribals, whom we refer to as aboriginals, the original inhabitants of this country. Because of whatever reason, they shifted from the mainland India and moved towards the forests. And in these forests, they maintain their own identity, distinctiveness, culture, language, script, all the practices. Now, they have a history as well. During the colonial period, we have had number of tribal uprisings as well. Sidhu, Kanu, so many tribal uprisings which we will discuss in modern history. Now, the question was, how do we deal with these tribals under the Constitution? because now we are an independent country. Tribals are also part of an independent India. How do we deal with them? What is the policy that we will follow with respect to these tribals? One policy was integrate them completely with the rest of the country. And let's have common set of structures, common laws for the entire country. The other way would be respect the diversity of India, the tribal diversity that we have. And don't treat tribals as a single homogeneous group. You may call 10, 20, 15 as tribal groups, but all of them are different from each other, unique from each other, distinctively unique from each other. So tribals are not a homogeneous group. Just like the people inhabiting the mainland India, we are not homogeneous. So there may be Tamils, there may be Kannadigas, there may be Malayalis, there may be North Indians, there may be Gujaratis, there may be Marathis. And within Maharashtra also, there is a different unique identity for different groups in Maharashtra. Similarly, calling all tribals as one would be foolish, because within the tribals, there is a lot of diversity further. That is why we have to look at tribals who are from states Assam, Meghalaya, Mizoram, and Tripura. We will give them protection under Schedule 6 of the Constitution. And in the rest of the country, wherever there are tribals, we will identify them and we will give them protection under Schedule 5 of the Constitution. But sir, why different treatment for tribals in these 4 areas, in these 4 states, and tribals in the rest of the country? When we look at tribals in the rest of the country, the argument given by constitutional experts is, if there are tribals in Jharkhand, if there are tribals in Chhattisgarh, all these tribals, more or less, they are similar to each other. That means we may, to a large extent, call these tribals of Chhattisgarh, Jharkhand, Rajasthan, Gujarat as some sort of a homogeneous group. But still we need to protect them. And what should we protect? We should protect their economic interests. But so far as tribals of Assam, Meghalaya, Mizoram, and Tripura are concerned, for example, in Meghalaya, we have 3 different tribal groups: Garos, Khasis, Jaintias. These are also 3 hills in Meghalaya, which is something that I'm sure you would discuss in geography. But Garos and Khasis are unique and different from each other. Jaintias and Garos are different from each other. That means in these 4 states, tribals cannot be treated like a homogeneous group. One tribe is different from another tribe, unique. That is why we need to give them extra protection under Schedule 6 of the Constitution. But so far as tribals in the rest of the country is concerned, and we have 11 states in India where we have these tribals, Constitution says give them protection under Schedule 5 of the Constitution, but protect only their economic interests. How? President has the power. What is the power available with the president? President can establish, president can alter, president can abolish a scheduled tribal area. A tribal area where there is a significant tribal population in the entire country except Assam, Meghalaya, Mizoram, and Tripura. What the president can do, identify a state, identify an area of a state where there is a significant tribal population, he will establish a scheduled tribal area. That means a tribal area which is under Schedule 5 of the Constitution, means it's a scheduled tribal area. President can abolish a tribal area, alter a tribal area, establish a tribal area. And then Governor has the responsibility. Governor has the responsibility to ensure the administration of the scheduled tribal area, which means governor will administer a scheduled tribal area. And this time, in administering the scheduled tribal area, the governor may not even go by the advice of chief minister and his council of ministers. This is another reason why the office of governor should continue, because in absence of the office of governor, we cannot imagine any other institution performing this task where the governor administers a scheduled tribal area, even without the aid and advice of the chief minister and the council of ministers. And how governor administers the scheduled tribal area? By establishing a council known as Tribes Advisory Council. In this Tribes Advisory Council, 3/4 members will be the tribal MLAs, rest nominated by the governor. Schedule 5 of the Constitution talks about the administration of a scheduled tribal area. President can establish a tribal area, can alter a tribal area, can abolish a tribal area. And now it is the responsibility of the governor to administer this tribal area. How will the governor administer this tribal area? By setting up a Tribes Advisory Council. What is this Tribes Advisory Council? For example, we have the state of Jharkhand. We know that in all the legislative assemblies in India, there are seats reserved for SCs, seats reserved for STs. Wherever there is an ST population, the seats are reserved for STs, the seats are reserved for SCs. Now in Jharkhand, for example, if a Tribes Advisory Council is established by the governor, 3/4 of the members of this Tribes Advisory Council will be the tribal MLAs. That means in this particular state, where seats are reserved for STs in the Legislative Assembly, those MLAs will become part of this Tribes Advisory Council. 3/4 of the members of this Tribes Advisory Council will be the tribal MLAs. The remaining would be nominated by the governor. What will be the role of this Tribes Advisory Council? As the name suggests, it will advise. Advise whom? Governor. On what grounds? How do you administer this scheduled tribal area? But sir, you told me that in Schedule 5, only economic interest should be protected. Because the only purpose of a Schedule 5 is to protect these tribals in their economic areas. That means the role of this Tribes Advisory Council is to advise the governor whether a law passed by parliament or a law passed by the state legislature, if this law talks about land transfer, if this law talks about transfer of land to non-tribals, if this law talks about money lending, whether this law will apply to this scheduled tribal area or not, or whether this law will apply with these modifications, that is something that will be advised to the governor by this Tribes Advisory Council. But this advice is not binding on the governor because it is only an advice. But nevertheless, the governor, in administering this tribal area, would consult this Tribes Advisory Council. Long story short, Schedule 5 and Schedule 6 of the Constitution it talks about the administration of the tribal areas. And who are these tribals? Different, unique individuals, unique groups. Schedule 5 talks about that we should protect only the economic interests of the tribals. How? The president will establish a tribal area. Once it is established, it is the job of the governor to administer this tribal area. How will governor administer this tribal area? By setting up a tribes advisory council. 3/4 of its members would be the tribal MLAs, remaining nominated by the governor. What will be their role? Their role would be to advise the governor that, dear governor, there is a law passed by the state legislature. Dear governor, there is a law passed by the parliament with respect to land acquisition. Whether this tribal land can be transferred to non-tribals or not. Whether this tribal land can be given to Adani for the construction of a factory. Whether this tribal land can be given for industries. Whether money lending can be allowed in this tribal area or not. Whether this law passed by the state legislature or the parliament with respect to the economic interest of the tribals, whether these laws will apply to this tribal area or not, or will apply but with these modifications. Who will recommend, who will advise? This tribes advisory council. But this recommendation, this advice is not binding on the governor because it's only an advice. That means the title of this council is Tribes Advisory Council, to advise the governor. Governor has a special responsibility in administering these tribal areas. But so far as Schedule 6 is concerned, it talks about administrative provisions. How do we administer these tribal areas? But this time, the tribal areas in 4 states, Assam, Meghalaya, Mizoram, and Tripura. Why? Because when we look at the tribals of these 4 states, one tribe is different from another tribe. We can't treat them as homogeneous group. But when we look at the tribals of the rest of the country, there we see that there is a tribe and the another tribe and the another tribe, but they can be viewed as some sort of a homogeneous group where there is hardly any difference between one tribe and the other tribe. And it's not that the entire Assam, Meghalaya, Mizoram, and Tripura, these are the tribal states. There are 3 districts in Assam, 3 districts in Meghalaya, 3 in Mizoram, and 1 in Tripura. These are scheduled tribal areas in these 4 states. But since these tribes are different, unique from each other as well, Constitution says we have to protect not only their economic interests, but their culture. In Schedule 5, those areas which are under Schedule 5 of the Constitution, the provisions are we have to protect their economic interests. That means when it concerns money lending, where it concerns land, we have to protect those interests. But the areas under Schedule 6 of the Constitution, for these tribes, we have to protect not only their economic interests, but their customs, their language, their script, their family structure, everything we need to protect. And that is why Constitution says, for example, Meghalaya. In Meghalaya, if there is a district where there is one tribe dominating, a district where one tribe is residing, convert that district into an autonomous district. Listen to me carefully. Convert that district into an autonomous district. And this autonomous district will be provided with a district council. This district council is a democratic body. How? It's different from Tribes Advisory Council, where MLAs are nominated to this council, where other members are nominated to this council. But this district council is a democratic body, which means elections, that too direct elections. That means in Meghalaya, if there is one district, Khasi, where Khasis are residing, convert that district into an autonomous district. And this autonomous district will be provided with a district council. In this district council, people, that means Khasis, will directly elect their representatives. For example, if in this district council, it has 30 members, 26 will be elected, 4 will be nominated by the governor. But then what is the role of this district council? The role of the district council is that it will have a body which will have legislative powers. Another body will have executive powers. Another body will have judicial powers. Another body will have financial powers. Listen to me carefully. At the center, we have Lok Sabha. People of this country directly elect their MPs to Lok Sabha. At the state level, we have the State Legislative Assembly, where people of that state directly elect their MLAs. At the village level, we have Panchayati Raj institutions. At the city urban area level, we have municipalities, urban local bodies. But so far as these tribal areas under Schedule 6 of the Constitution are concerned, we have given them some sort of autonomy. Autonomy in the sense that you will have a district council. In your particular district, it is as if you are running your entire country. You are running your own country. Because you will decide what are the taxes that you will impose on the people. You will decide what are going to be the laws related to education, laws related to marriage, laws related to inheritance, laws related to divorce. You will have the power to establish your own schools, govern your entire district without any interference from the state government, without any interference from the central government. That means now this district becomes some sort of an autonomous district where it is run by this district council on its own. And through this, we protect not only the economic interest of the tribals, but their social customs as well. Because whatever laws are related to marriage that they will decide, divorce, inheritance, how taxes can be imposed on the people, how taxes can be collected. And if there is a problem, if there is a dispute between two groups in this particular district, we will not go to a high court. We will go to this tribal court and it will administer justice based on its own tribal custom. Not based on Indian Penal Code, not based on Criminal Procedure Code, not based on any other code or any other law. Based on their own tribal judicial customs, they will decide who is guilty and who is not. So in the entire country, if we can call the entire country as an ocean, in this ocean there is an island and this island is autonomous, that is a district council. But what if there is a district where one tribe is not dominating, where only one type of tribe is not residing, there are two tribes. Let's say tribe A, tribe B. Normally what happens? The state government declares that this A this area which is inhabited by tribe A is converted into a district. Area which is inhabited by B, tribe B, is converted into a district. But what if it is not? Then A and B areas are converted into autonomous regions. And these autonomous regions are given regional council. And this regional council, people of this A area will directly elect their members. And they will decide then what sort of laws should be implemented here, what sort of justice should be given there. That is why if you look at when the law is passed by the parliament, these laws are not automatically applied to Schedule 6 areas. When a law is passed by the parliament, we say that this law is not automatically applicable to the Schedule 6 areas. In case of Assam, governor will decide whether this parliamentary law or this law passed by the state legislature, whether it will apply to the scheduled tribal areas of Assam or not. So far as Meghalaya, Mizoram and Tripura is concerned, governor and the president. Governor will decide whether a state law will be applicable to these areas or not. And president will decide whether a parliamentary law will be applicable to these states or not. And these Panchayati Raj institutions, they are present in Schedule 5 areas, but absent in Schedule 6 areas. Sir, what does that mean? I will club the two schedules together. Schedule 5, Schedule 6 of the Constitution. What is the purpose of both these schedules? To protect the interest of the tribals. But tribals are not a homogeneous group. That is why tribals of Assam, Meghalaya, Mizoram and Tripura are dealt separately under Schedule 6, and the tribals of the rest of the country are dealt separately under Schedule 5 of the Constitution. And those who are under Schedule 5 of the Constitution, we need to protect only their economic interests. But so far as the tribals of Schedule 6 area is concerned, we have to protect not only their economic interest, but their social customs as well, their religion as well, their language as well, their script as well, their judicial structure as well. That is why in Schedule 5 area, the president has the power to establish a tribal area. And then the governor of that state will have to administer that tribal area on the recommendations of Tribes Advisory Council. But the role of this council is limited in giving advice and limited in advising the governor with respect to economic matters of these tribals, which means with respect to matters related to land, related to money lending of these tribals. But when we look at tribal areas under Schedule 6 of the Constitution in Assam, Meghalaya, Mizoram and Tripura, we want to give these tribals autonomy. That means run the way you want to run. We will not interfere. And for that, if there is a state, for example, Meghalaya, where there is one tribe group, Garos, who are inhabiting one district, that means Khasis, all the Khasis are residing in Khasi district, Garos in Garo, Jaintias in Jaintia. Now, all these three districts are converted into autonomous districts. And these autonomous districts are provided with district council. That means people of Garos, they will elect their representatives in this district council. And then they will make their own laws. They will implement their own laws. They will impose their own taxes. They will punish people based on their own tribal culture whenever they have violated the tribal laws. Autonomy. But now there is a parliamentary law, let's say with respect to Uniform Civil Code, Let's say tomorrow a uniform civil code is passed, or let's say tomorrow land acquisition is passed. If I am the governor of Assam, I get to decide whether this parliamentary law will apply to Schedule 6 area or not, whether the state law will apply to this tribal area or not. I am the governor of Assam. Governor of Assam is given special responsibility. So far as the governor and the president is concerned, in states such as Meghalaya, Mizoram, and Tripura, the governor of the state will get to decide whether the state law will be applicable to this tribal area or not. And the president will get to decide whether parliamentary law will be applicable to these areas or not. Which means these district councils, these are basically democratic councils. When these are democratic councils, that is why we don't need Panchayati Raj institutions there. Why? Because if Panchayati Raj institutions are also established, it would be like duplication. Two democratic bodies performing the same duty. That is why Panchayati Raj institutions are absent in Schedule 6 areas, but they are present in Schedule 5 areas. Sir, why are they present in Schedule 5 areas? Because Tribes Advisory Council is not a democratic body. Clear? If, for example, there is a state, Assam, Meghalaya, Mizoram, and Tripura, where there is a district, but this district is not inhabited by one tribe. There are two tribes inhabiting this district. This entire district will be divided into two autonomous regions. These two autonomous regions will be given their own regional councils. These regional councils will have people directly elected by these tribals, and then they will pass laws for their own region. They will pass laws for their own region, implement laws in their own region, providing justice to their own people in this particular region. That is how we protect not only the economic interest, but also the social customs, religious customs, language, script, the family structure of these Schedule 6 areas. That is Schedule 5 and Schedule 6. So is it to say that whole Indian constitution does not apply to tribal area? No, the constitution applies, but when it comes to their cultural matters related to their language, related to their script, related to their customs, we say they have autonomy. When we say Indian constitution is applicable, that means if the state is violating their fundamental rights, they can drag the state to the court. They have the reservation in government jobs and in educational institutions. They can also approach the President of India. Okay. Then there is Schedule 7 of the Constitution, which talks about distribution of legislative subjects. You have enrolled in BYJU'S and you want to prepare for the civil services examination. Clear? And you know BYJU'S will teach you all the subjects. But then internally, we have to divide the subjects as well. I'll teach polity, Sham sir would teach economics, Chetan sir would teach IR, Mishra ji would teach history, Mukesh Jha will teach geography. We've divided the subjects. In a similar fashion, if legislature of India has to pass laws on various items, we will have to divide these subjects as well. Some subjects will be given to parliament. You can make laws on this. Some subjects are given to states. You can make laws on this. And some subjects are common, where both parliament as well as state legislature will have the power to make laws. Those items where parliament has the sole power to make laws are in union list. For example, defense, atomic energy, foreign affairs, communication, banking, insurance. Those areas where the state has the power to make laws, they're under state list. For example, public order, prisons, local government, agriculture, fisheries, theatre, so on and so forth. And those where both center as well as state has the right to make law, power to make law, those are in concurrent list. For example, education, for example, electricity, for example, registration of births and deaths. And all this we will discuss in great detail in center-state relations. And hopefully we will initiate a discussion on this center-state relations today. Clear? Then we have Schedule 8 of the Constitution. And Schedule 8 talks about Indian languages. Originally, there were 14 languages mentioned under Schedule 8 of the Constitution. The current number is, how many languages do we have under Schedule 8 of the Constitution? 22 languages. And these are the 22 languages which are mentioned under Schedule 8 of the Constitution. But when we look at this chapter language, we can divide this chapter into 4 parts. One, what is the official language of the Union? Second, what is the official language of a state? Regional languages. What is the languages of the judiciary and the text of laws that are passed by the parliament? And what are some special directives vis-a-vis language? Let's first look at what is the official language of the Union. But first you need to know what do we mean by official language. In which language am I discussing these matters today? English. That means we will use English as a mode of communication between the teacher and the students. We have a separate batch where only Hindi will be taught. No word of English would be spoken. That means there the medium of instruction is Hindi. Now I am center and you are states. In what language will we communicate with each other? That is known as the official language of the Union. There has to be a language which should be used to communicate with each other. Center has to issue directives to the states. In what language? For example, the current government will issue a directive to Tamil Nadu government in Hindi. They would never agree. And they would say it is not acceptable to us because I did not even understand what you mean by it. There will be chaos, confusion. And the Tamil Nadu government would reply in Tamil. Mr. Modi will not understand. So for the sake of clarity, we need an official language which we can use to communicate with each other, which the union government will use to communicate with other states, which the union government will use to communicate with each other's departments. And that language is Hindi in Devanagari script. So according to the Constitution, what is the official language of the union or the central government? That is Hindi in Devanagari script. But Constitution says that previously we were using English. And in 1950, we cannot suddenly shift to Hindi. We need to prepare ground for it. It can't be an overnight decision. That is why Constitution said that for 15 years, English will continue. Although official language of the Union has to be Hindi, but we will implement this in 1965, 15 years later. For these 15 years, English will continue as the official language of the Union. But then every 5 years. And then every 10 years, there should be a committee and the committee of the parliament on the official language. Sir, what does that mean? What is the official language of the Union? Hindi in Devanagari script. What is the national language of India? There is no national language of India. There is only one, there is only official language. There is no national language. So Hindi is not a national language. Hindi is the official language of the Union. But the same constitution says, if we were using English before, we will continue to use English after as well, but only for 15 years. Once 15 years are over, only Hindi will continue as the official language of the Union. English will disappear. Because we can't make a shift immediately, instantly. We need to prepare ground for it. And for that, we will have a committee and we will also have a commission on the official language. That means one commission will be set up. What will be the job of this commission? It will advise the government that these are the areas where we should stop English. And these are the areas where we can only pursue Hindi. For example, this commission would say that Hindi should be used by the Union when it is interacting, when it is communicating with the northern states. That means we can make this shift even now itself, 1950 itself, 1955 itself. And while communicating with the southern states, we should continue to use English till 1965, maybe. And whatever report is given by this commission will be then examined by the committee of the parliament. And when would this commission and committee be set up? Constitution says first in every 5 years. That means in 1955. Then after 10 years. That means in 1960. A committee was set up in 1955. Official Language Commission, which was headed by B.G. Kher. And then the report of this commission was to be looked into by the committee of the parliament. That committee of the parliament was headed by Govind Ballabh Pant, GB Pant. What was the job of this commission? The job of this commission was to recommend in what areas can we stop the use of English, in what areas can we exclusively use Hindi, because come 1965, English will disappear as the official language of the Union. Hindi alone will be the official language of the Union. This commission was set up in 1955, but a committee which was envisaged in 1960, which should have been set up in 1960, after 10 years of the commencement of the Constitution, was not set up. Why? Because we witnessed chaos, confusion, protests, emotional issues. Where? Particularly in South India, and more specifically in Madras, which is today's Tamil Nadu. People of southern states, particularly Madras, protested. Why should Hindi, which is a recent language, a new language, be imposed on the unwilling population of South India? Because in South India, we have our own beautiful classical languages. Tamil is a classical language. Kannada is a classical language. Odia is a classical language. Malayalam is a classical language. Telugu is a classical language. So why should our beautiful old classical languages be discriminated against, and Hindi, which is a recent language, be imposed on the unwilling population of the South India? This is not acceptable to us. In fact, we can't speak Hindi. We can't understand Hindi. So why should Hindi be the official language of the Union? We will not accept this. There were protests and there were few deaths as well. In fact, there was this anti-Hindi agitation in Madras. And Tamil Nadu government, Madras government then, it went to another extreme. It said whoever died in these anti-Hindi protests, anti-Hindi imposition protests, we will give them money as well. We will give them compensation as well. And we will give them pension as well. For their entire life, their families would get the pension. Those who died in this anti-Hindi agitation. Ultimately, a compromise was reached. What was the compromise? Official Languages Act was passed by the Indian Parliament in 1963. And this law says that both Hindi as well as English will continue to be the official language of the Union, notwithstanding anything. Notwithstanding the fact that Constitution says that English will not continue beyond 15 years of the commencement of the Constitution. Notwithstanding that, both Hindi and English will now be the official language of the Union. But sir, I have a question. Yes, what is the question? Sir, you said any law passed by the Parliament cannot violate the Constitution. If the Constitution says that the official language of the Union is Hindi in Devanagari script, and only for 15 years English will continue, after that Hindi will be the only sole official language of the Union, how can Parliament pass a law, that to an ordinary law, passed by simple majority, and say English and Hindi both will continue forever and ever and ever, there is no expiration term? How is that possible? That's possible because Constitution has allowed it. What Constitution has allowed? Constitution says maybe the Constituent Assembly could anticipate something on this matter. Maybe they could anticipate that language is an emotional issue. Maybe they could anticipate that Hindi may not be acceptable to the people living south of India. That is why Constitution said Hindi will be the official language of the Union, but for 15 years English will continue. Can English continue beyond 15 years as well? Yes. For that, Parliament can make a law. And this law shall not be deemed as amendment to the Constitution. That means Parliament can enact a law, and through this law says, forget about expiry of 15 years. Even beyond 15 years, we can have English as continuing as the official language of the Union. That means a law can be passed by the Parliament, which is not amendment to the Constitution. That means there are some features of the Constitution which you can change by simple majority. That means Parliament can enact a law, and through this law, the Parliament can say, even if we said that 15 years is the expiry term of English, English can continue beyond 15 years as well. For that, you don't need to use Article 368. And to resolve the crisis that we witnessed in India against the Hindi imposition, the law was passed by the Parliament called Official Languages Act, and it is this Official Languages Act which says Indian Union, the Union of India, will have two official languages, Hindi as well as English, without any expiry term. And in Parliament also, for all the transaction of business, both Hindi as well as English will be used. While communicating with the states, both English and Hindi will be used. When the central government communicates with the people, both English as well as Hindi will be used. That is the official language of the Union. So, official language of the Union, according to the Constitution, is Hindi in Devanagari script. But according to the Official Languages Act, it is both Hindi as well as English. Which means it is this act which enables the use of English indefinitely without any time limit. So what is Schedule 8 of the Constitution? It talks about 22 Indian languages. This chapter languages can be broken into 4 areas. First, what is the official language of the Union? And now we have understood that although according to the Constitution, The official language of the union shall be Hindi in Devanagari script. But constitution allows that English could be used for 15 years. Constitution allows that even beyond 15 years, if parliament wants, it can enact a law and continue and extend English for indefinite period. And parliament enacted a law known as Official Languages Act. Now, whether there are the proceedings of parliament, whether there is communication between the central government and the state government, all this can be done in both the languages, Hindi as well as English, because both are the official languages of the union. But so far as a national language is concerned, it does not exist. But what about regional languages? The states are free to choose their language. This is what we call linguistic federalism. If the constitution would have empowered the center, that center you decide what should be the official language of a state. Official language of the state? In what language Tamil Nadu Legislative Assembly will function? How Tamil Nadu government would communicate with its own citizens, with its own residents? Then are we a federal polity? We are a unitary setup, where the center gets to decide what should be the official language of a state. But center does not get to decide. States get to decide themselves. That is linguistic federalism in us. West Bengal, you can decide your own official language. Tamil Nadu, you can decide your own official language. And not just one language, any number of languages. And constitution does not even say that their state, you have to choose the official language of the state only from this list. Now, you can even go beyond Schedule 8 of the Constitution and choose a language as the official language of your state, even if it is not mentioned in the 8th schedule of the Constitution. Which means what is going to be the regional language? Constitution does not specify the official language of different states. That means giving states their own power. You decide your official language. Linguistic federalism. The legislature of a state may adopt one or more languages as the official language of the state. That means it's not necessary to have only one language. For example, in Telangana, it can be Telugu, it can be Urdu as well. Both these are the official languages of Telangana. It can be English as well. You can choose one or more languages as the official languages of the state. You can choose a language even if it is not mentioned in the Schedule 8 of the Constitution. For example, West Bengal. Bengali is an official language. Kurk, which is considered to be a language belonging to the Dravidian family. It is also the official language of West Bengal because the West Bengal legislature gets to decide 1, 2, how many official languages do we have. And even if a language is not mentioned in the Schedule 8 of the Constitution, that language also you can choose as the official language of your state. That is the regional language. But how will the union and the states communicate with each other? Both in Hindi as well as English? Because that's the official language of the union. But in what language will the states communicate with each other? Hindi as well as English, because that is the official language of the union. But states are free. If the states agree, they are free. Free to do what? To use only Hindi instead of English. And that is how some states such as Uttar Pradesh, Madhya Pradesh, Rajasthan, Chhattisgarh, they have decided that whenever we interact with each other, whenever we communicate with each other, we will not communicate in English, we will communicate only in Hindi. That is okay, that is provided. Which means how states are going to interact with each other. They can use Hindi as well as English. But we have empowered the states. If you want, you can only use Hindi in your communication. And that is how some of the northern states, they have an understanding with each other that whenever we will communicate with each other, we will communicate only in Hindi and not in English. But what about the language of the judiciary and the text of the laws? English will be used in all the proceedings of the Supreme Court and in every High Court. Some of you may have witnessed the live proceedings of the Supreme Court. Because thanks to Supreme Court, now constitution bench cases, a case involving 5 judges or more, they are live streamed on the YouTube channel of the Supreme Court official. And you would only hear English being spoken at the Supreme Court. Only English is spoken at the High Court. Because what is going to be the language of the superior judiciary? High courts and Supreme Court, we call them superior judiciary. The language is only English. No Hindi, no any other language, only English. But what is going to be the language of the district courts? Subordinate courts, regional language. Which means if we are in Karnataka, High Court will use English. Supreme Court will use English, only English. But the local courts in Karnataka, the district courts in Karnataka, will use their regional language, their own official language, which is Kannada. Not just that, the authoritative text of all bills, acts, ordinances, orders, and bylaws at the central and the state level, English will be used. In fact, our constitution is in English. Although the translation of this English constitution was also done, but in 1950. That means we had 2 copies, Hindi constitution, English constitution. But listen to me carefully. When we had 2 copies of the constitution, Hindi as well as English, but later the constitution was amended. First constitutional amendment, second, third, fourth, fifth, so on and so forth. Only the English constitution was updated. Hindi constitution was not. Then Mr. Vajpayee became the prime minister in 2003. He decided to amend the constitution and said, now all these amendments to Indian constitution which have taken place, all those translations will also be done. And this authoritative text in Hindi language of Indian constitution would have the same sanctity as the constitution itself. So what does that mean? That means in 1949, when constitution was adopted, we had 2 constitutions in different languages, Hindi and English. Both are the constitution. Both have the same sanctity as the constitution. But later on, when the constitution was amended, only the English constitution would be updated, not the Hindi one. Mr. Vajpayee became the prime minister and said from now onwards, even an amendment to the Indian constitution would have to be translated in Hindi as well, so that this Hindi constitution is also updated with the amendments. And now this amendment to the Hindi constitution is also the authoritative text of constitution. That means it has the same status as that of the English constitution. Similarly, there has been an instance where an individual filed a habeas corpus petition in Hindi. This matter reached the Supreme Court. Supreme Court rejected this petition, saying we use English only and not Hindi in the communication. So in the superior judiciary, which is the High Courts and the Supreme Court, only English is used. But now, thanks to Chief Justice of India, Justice Chandrachud, What Justice Chandrachud has said, all the judgments that we have been giving, all the judgments that we will be given, we will use artificial intelligence tools to translate these judgments in the local languages as well, in the regional languages as well, so that these judgments are understood by the lawyers who are working and operating at the district level where regional languages are used, so that these judgments are understood by the common people as well in their own language. But what is the language to be used at the High Court and Supreme Court? English only, although the judgments can be translated as well. And what is the language to be used at the district level, subordinate level in a state? Their own regional language. Clear? Then what are some special directives? Article 350 of the Constitution. I have a complaint. The complaint is, I am not given the ration card. I am in Tamil Nadu. I am not given Aadhaar card. I am in Tamil Nadu. Clear? I will have to approach the authorities in Tamil Nadu. Why are you not giving me the ration card? Why are you not giving me the Aadhaar card? In which language should I communicate? I have a grievance. I have a complaint. In what language should I communicate with the official in Tamil Nadu? In any language which is spoken in Tamil Nadu and any language which is spoken at the Union. What is the language spoken at the Union? English as well as Hindi. What is the language spoken in Tamil Nadu? English as well as Tamil. But I can file this complaint in Hindi language as well. Because every aggrieved individual, every individual who has an issue, who has a problem, who has a concern, has the right to submit representation to address this grievance in any language which is used in the union or in the states. For example, in Uttar Pradesh, I can submit my complaint in English only. Because in Uttar Pradesh, Hindi is the official language. But since English is the language used at the center as well, I can submit this complaint in English language as well. That's Article 350 of the Constitution. Article 350 capital A is something that we have discussed multiple times. We are in Tamil Nadu, but there are migrants from Maharashtra. That means these are linguistic minorities. It shall be the duty of the state of Tamil Nadu to provide education to the children of these linguistic minorities in their own mother tongue, which is Marathi, till at least primary stage of their education, till 5th standard. That's a special directive vis-a-vis language. And a constitutional body is created, known as a Special Officer for Linguistic Minorities. All these linguistic minorities, whether Marathis in Tamil Nadu, whether Tamils in Delhi, whether Bengalis in Delhi, whatever problems you are facing because of your language, whatever concerns that you have, whatever discrimination you are facing because of your language, you just have to approach the officer appointed by the president, a constitutional officer known as the Special Officer for Linguistic Minorities. And it will be the job of this individual to investigate all matters relating to the constitutional safeguards for linguistic minorities. Any problems that you have, get in touch with the special officer. He will investigate, submit report to the president, and president will take the action. In fact, this is a state. Listen to me carefully. This is a state where there is one linguistic minority. In the rest of the state, X language is spoken. In the remaining part of the state, Y language is spoken. But here is this small language, Z. Those who speak this language, they also want protection. They also want dignity. What they can do, they can approach the president. Madam President, said, what? We are linguistic minorities in our own state. We want our language to be protected, preserved. Said, yes, you can do that. Article 29 is your fundamental right. Every section of citizens residing anywhere within the territory of India, if you have a distinct language, script, and culture of your own, you have the fundamental right to preserve that culture. So that's your fundamental right. Yes, ma'am, but um, we want our language also to be recognized as the state official language. President has to listen to this and refer this matter to the state. There are people in your state who need protection, whose language needs to be protected. Their claim is that our language should also be made as the official language. Please consider. That is also the job of the President of India. Because language is an emotional issue in India. Every now and then you will hear Hindi being dominated, Hindi being imposed. Is this right or wrong? This at least is constitutional. So you may accuse the central government of using Hindi at the expense of other languages, but they are not doing anything unconstitutional. Because Article 351 of the Constitution imposes a duty on the union, on the central government, that what you have to do, you have to promote Hindi. So that Hindi serves as the medium of expression for all the elements of the culture, of the composite culture of India. They say, look at Germany. Germany is developing because the entire country speaks one language. China is developing because the entire country speaks one language. Japan is developing because the entire country speaks one language. Why can't we also speak one language? And that one language can be Hindi. Right or wrong? But Germany is speaking one language because there is no diversity in Germany. There was no diversity in Japan. There is no diversity in China. But there is linguistic diversity in India, where people speak multiple languages, different languages. You can't impose one language on the entire country, at least not through force. If people voluntarily adopt Hindi, learn Hindi, understand Hindi, speak Hindi, then over a period of time, Hindi can emerge as one common language which can bind the entire country together. Because let's also accept, Hindi is a language which is at least understood, if not spoken well, by majority of the people in India. English is the language of elites, or the educated class at least. Beyond Tamil Nadu, Tamil would not be understood. Beyond Andhra and Telangana, Telugu would not be understood. Beyond Gujarat, Gujarati may not be understood. But beyond the borders, if there is one language which can be understood, at least understood by the majority, if not spoken by the majority, that is Hindi. So over a period of time, we can take steps without imposing Hindi, but we can take steps so that Hindi is also popularized in South India. And over a period of time, Hindi becomes a linked language which can link different people together. Because when I travel to Tamil Nadu, I don't know the language Tamil, a beautiful language, but I don't know it. So in what language should I link with the people of Tamil Nadu? What should be that linked language? That can be English, that can be Hindi. But English spoken by the educated class. Illiterate class, they may speak Hindi. So can Hindi become a linked language at least, which can bind the people of the entire country together? Yes, it can. And for that, there is a duty on the union that you have to promote Hindi so that Hindi becomes or serves as the medium of expression for all the elements of the composite culture of India. But sir, why Tamil Nadu people are so reluctant to Hindi? Sakshan, you tell me, why are you so reluctant to understand Tamil? You learn Tamil. Okay. Now, what are the classical languages? There are 6 classical languages: Sanskrit, Tamil, Telugu, Kannada, Malayalam, and the last one to be given the status of a classical language was Odia. To everyone's surprise, Hindi is not a classical language either. But what is a classical language? And how do we define language as classical? We say this is a classical movie, right? Casablanca is a classical movie. Shawshank Redemption is a classical movie. Mughal-e-Azam is a classical movie. Sholay is a classical movie. I'm sorry, I don't know much of the cinema in the southern India or the local regional cinema. Otherwise, I would have cited their examples as well. But that doesn't mean I don't respect diversity, just that I don't watch. Classical movie or a classical song is something which stands the test of time. Casablanca, very old movie. Even today, people watch it. Why? Because it has stood the test of time. It's considered to be the most romantic movie of all time. Similarly, if there is a language which has a long history and is still being used today, it has not disappeared, it has not gone extinct, it is still being used today and flourishing, that language is a classical language. High antiquity, that means it's a language where the texts of this language date back to 1500 to 12,000 years. And it should be original, not derived from other languages. It should be an original language. Such languages are what we call classical languages, recognized by the center. But then what is the benefit of a classical language? The benefit is, once a language is declared classical, it gets financial assistance for setting up a center of excellence for the study of that language. The only way we can protect a language, preserve a language, promote a language, is if more and more people opt to study this language. If we can set up centers in different parts of the country where this language would be taught, we will see more and more people opt for this language, study this language, and hence this language would be preserved. For that, we need money. And financial assistance is given as soon as your language is declared as a classical language, so that on this particular language, we can set up a center of excellence. Once a language is declared classical, University Grants Commission can be requested to create, at least to start with central universities, number of professional chairs for classical languages for scholars of eminence in the language. What does that mean? You want to enroll in a graduate or a postgraduate program in a university. What is the thought process in your mind? You will opt for that course provided it gives you later employment opportunities as well. If a classical language has a course in central universities, I may opt for it. Why? I will see there will be less takers for Sanskrit language, which means there will be less number of students, which means there is less competition as well. Because for Sanskrit, we will have departments in all the universities in India. Less number of takers, that means the supply is less, but demand is good. Ultimately, I will get a better job. So if for these classical languages, in all the central universities, if they're the scholars of this language, they will get to teach, which means more and more people will opt for this program. Language will be documented, language will be preserved, language will not go extinct. That is what happens when a language is given a classical language status. But in 1963, when there was a compromise we reached, that okay, let's not push Hindi as the only official language of the Union. We will have Hindi as well as English as the official language of the Union. At the same time, three-language formula was also prescribed. What is this three-language formula? That means the kids the students till the 10th standard should be taught 3 languages. If it is southern India, your own regional language, which may be Tamil, Kannada, Telugu, Malayalam. Second language would be English. Third language would be Hindi. That means in southern India, 3 languages should be taught to the students. Their own language, so that they don't protest our language is being discriminated against. English, because English is no longer only a language, English is a skill. And this skill gives you good access to quality jobs. And third, Hindi, so that Hindi is also popularized in South India. Because Article 351, it shall be the duty of the Union to promote the spread of Hindi language so that Hindi emerges as the medium of expression for all the elements of the composite culture. Same compromise in North India as well. So people in North India, students in North India, kids in North India will also be taught 3 languages. One, Hindi, which is their language, local language. Second, English, which is now a skill. And third, they should preferably select a very strong, beautiful South Indian language. So that South Indian languages are promoted in Northern India. Hindi is promoted in the Southern India. Beautiful. This was the 3 language formula. But over a period of time, we have seen something else. Tamil Nadu says we don't agree with 3 language formula. We will agree with 2 language formula. We will only teach Tamil and English. Meghalaya does the same thing. We will teach only 2 languages. Tripura says the same thing. We will teach only 2 languages. North Indian states say if we have to teach Hindi, English and third language, this third language should be Sanskrit. We will not teach the South Indian languages. So we can say that this 3 language formula, which meant that the state government should adopt and vigorously implement the 3 language formula, which includes the study of the modern Indian language, preferably one of the southern languages, apart from Hindi and English, in Hindi-speaking states, and of Hindi along with regional language and English in non-Hindi states. But what has happened is Hindi is not taught in the states of Tamil Nadu, Tripura and Puducherry, says the Ministry of Home Affairs. If you notice closely, Leonardo DiCaprio was mind-blowing in Shawshank Redemption. You might have watched a different Shawshank, because in my Shawshank there is no Leonardo, but separately. If you look at Ministry of Home Affairs, there are various departments. Department of Home, States. One is the Department of Official Language. Why this department was kept in Home Ministry? Because on official language there would be protests. There was a danger, a threat to internal security because of this official language. That is why this department is in the Home Ministry, Department of Official Language. And Home Ministry has said that when it's Hindi, Hindi is not taught in the states of Tamil Nadu, Tripura and Puducherry. In many Hindi-speaking states, Sanskrit became the third language instead of any modern regional language, preferably South Indian language. Whereas the non-Hindi speaking state like Tamil Nadu operates through a 2 language formula, Tamil and English, says the Ministry of Home Affairs. Now we have a new national education policy, which we will discuss in social issues, where there is another controversy on this 3 language formula, whether it is optional or whether it is mandatory. Because there have been states which are demanding that we should not overburden kids by forcing them to study 3 languages. 2 language formula is more than enough. But the states have the option to decide whether they want to implement a 3 language formula or a 2 language formula. Although the new national education policy encourages the states to vigorously implement 3 language formula. That completes our discussion on languages Schedule 8 of the Constitution. We'll discuss Schedule 9, then we will take up questions, then we will take a break, and after the break, we will discuss 10th schedule. But what is the Schedule 9 of the Constitution? We have discussed this multiple times, but we will just recap it now. First, Constitutional Amendment Act 1951. Ninth schedule was added to the Constitution. Any law which is placed in ninth schedule, Constitution said no judicial review. Judiciary cannot review the constitutionality of a law which is placed in ninth schedule, which basically means any law which is placed in ninth schedule has immunity. It cannot be reviewed by the judiciary. But then came Keshavananda Bharti case, which was decided by the court on the 24th April 1973, where the Supreme Court propounded a doctrine known as the doctrine of basic structure. There are some things which you cannot violate even by amending the Constitution. And in 1980, Supreme Court said judicial review is also part of the basic structure. The case was Minerva Mills. Now the question before the court was, in Vaman Rao, in I.R. Kolo, in 1981, in 2007, the question before the court was, what will happen to this law which is placed in ninth schedule? Can we review now these laws placed in ninth schedule? Because although the Constitution said no judicial review, but in 1980, the court said judicial review is part of the basic structure of the Constitution. In Vaman Rao versus Union of India, 1981, the Supreme Court said all laws placed in ninth schedule before this date, there will be no judicial review. But all laws placed in ninth schedule after 24th April 1973, there will be judicial review. Why? Because if on 24th April, Supreme Court innovated a doctrine called basic structure, one such basic structure is judicial review. That means any law placed in ninth schedule cannot get immunity. It has to be reviewed. It will be reviewed. It can be reviewed. Even if Constitution says there is no judicial review, because judicial review is part of the basic structure of the Constitution. But then in I.R. Kolo case, the Supreme Court said something else. For example, there is a law, listen to me carefully, which is placed in ninth schedule, but this law is placed after 24th April 1973. That means on this particular law, there can be judicial review. That means you can question the validity of this law placed in ninth schedule. Yes. But even then this law has some protection. This law can violate Constitution. But this law cannot violate basic structure. That means there is a law passed by the Parliament which says there can be no discrimination when it comes to public employment on the grounds of religion, race, caste, sex, place of birth, descent, so on and so forth. What if tomorrow state passes a law and says that in reserving posts in government jobs, we will discriminate on the grounds of residence. To prevent a challenge to this law, this is placed in 9th schedule after 24th April 1973. Will this law still get some sort of protection? Yes. Is this law violating the constitution? Yes, because constitution says there can be no discrimination on the grounds of residence. But when this law is placed in 9th schedule, if discrimination on the grounds of residence is not a basic structure, then this law will continue, even if it is violating the constitution, but it is not violating the basic structure. Similarly, there are states, for example, Maharashtra, where if you read today's newspaper, there have been protests demanding Maratha reservation. Some MLAs, some MPs belonging to Shiv Sena Shinde camp, they've also resigned. This protest has turned violent as well in Pune and in other areas. Now, if there are states such as Maharashtra, Telangana, Tamil Nadu, they want to extend reservation beyond 50%. And they place this law which have extended reservation beyond 50% in 9th schedule. If the court would have said that 50% cap, 50% limit on reservation is a basic structure, then these laws would be unconstitutional. Because you are placing this law in 9th schedule, but we can review it and you have violated the basic structure, these laws are unconstitutional. So Tamil Nadu, Maharashtra, Telangana cannot reserve seats beyond 50%. But if the court has said that 50% limit is not a basic structure, then if tomorrow Tamil Nadu, Kerala, Telangana, any state in India would provide reservation beyond 50%, although the constitution has said, although the Supreme Court has said in Indra Sani case that reservation cannot exceed 50%, but you're exceeding 50%, but you're placing this law in 9th schedule, you get protection. That means this law, even if it is placed after 24th April 1973, it gets a protection. It cannot violate the basic structure of the constitution, but it can violate other provisions of the constitution which are not part of the basic structure. So if there is a law which is violating the constitution, the law is unconstitutional. But if this is a law which violates constitution, but is placed in 9th schedule, it gets protection, the law is not unconstitutional. That means the only restriction is that this law placed in 9th schedule should not violate the basic structure of the constitution. That is schedule 9 of the constitution. And once we meet after the break, we will discuss 10th schedule of the constitution. But any questions, please let me know. Sir, as we see harassment in Tamil Nadu to people where the people talk Hindi got harassed by Tamils, can we complain it according to Article 350B? Yes, you can file a complaint before the Officer of Special Linguistic Minorities. Is it only Supreme Court who can decide what basic structure is? Yes. Who are the tribal MLAs? For example, MLAs who have been elected only because of their tribal status, because there are some seats which are reserved for tribals. Only the tribals can contest from those seats. Those are what we call tribal MLAs. So basically, any law placed in 9th schedule is subject to judicial review. Yes, if the law is placed after 24th April 1973. Sir, what about criminal laws in autonomous district? These are different from mainland or same as mainland. These are different. Their criminal system is based on their own tribal custom. Sir, judgment of Supreme Court have the same status as the law passed by the Parliament. Yes, under Article 141, any judgment of the court is basically the law of the land. So, can there be amendment in classical language to include other languages? Yes. Any questions further? Please let me know. But sir, EWS reservation has already extended the reservation beyond 50%, and Supreme Court has upheld that EWS reservation, saying it's okay. And we have discussed that in Article 16 of the Constitution. Tomorrow is Karnataka Rajyotsav. Yes, it is, because the state was created on November 1. But we will have a class. So alteration in classical language required Article 368? No, because it's not mentioned in the Constitution. Sir, scheduled chapter is not there in Lakshmikant. It is. Sir, why do we need Schedule 9 when laws placed under them is subject to judicial review? Originally, it was not subject to judicial review. So Schedule 9 was added in 1951. At that time, there was no concept of basic structure or judicial review as part of the basic structure. So the idea was to save laws which would violate fundamental rights. For example, laws which would implement land reforms, which would abolish zamindari system. Those laws should get protection in Schedule 9. There will be no judicial review. It was only later in 1973 that Supreme Court said there is something called basic structure. So the purpose of creating 9 schedule was to provide laws immunity from judicial review. And it did its purpose till 1973. Okay, let's take a break. We'll meet 7:55 a.m. and discuss the anti-defection law. See you on the other side of the break. Shall we start? Okay. Now let's discuss 10th schedule of the Constitution. You may have a lot of questions on this topic because it has been in the news recently. In today's newspaper, you will also find something related to Shiv Sena and what Supreme Court has said on anti-defection law. But park your thoughts. Don't ask any questions as of now. Just listen to me calmly, patiently. After 1.5 hours, once we will complete this topic, I'm sure you will have no doubt in your mind, but no questions, nothing, no comments, no commentary. This comment section should be clean. Just listen to me patiently. And once the class is over, then you rate the class as well and tell me whether you have understood this or not. Disqualification of legislators under anti-defection law. First, you have to be qualified in order to contest elections. For that, we have the qualifications. And later, once you're elected, you should not also come under disqualification. If there is a change in the nature of citizenship, if you are adjudged insolvent, if you are declared mentally unfit, if you are holding an office of profit, you will be disqualified. But Constitution further says extra disqualification grounds can be prescribed by Parliament by law. So what Parliament can do, Parliament can enact a law, and through this law, it can mention additional grounds on the basis of which you can be disqualified. And I've told you then that there are two laws which have been passed by the Parliament. One is the Representation of the People Act 1951, which we will discuss in elections chapter, and the other is anti-defection law. Under this law also, a legislator can be disqualified. But what is this defection? Floor changing, party hopping. What is this floor changing? On the floor of the Parliament, there is a seating arrangement. On the floor of the legislature, there is the seating arrangement. On one side, you will see the members of the ruling party are sitting. On the other side, you will see the members of the opposition sitting. What if there is a legislator who crosses the floor, moves from opposition to the government, or moves from government to the opposition? Party changing, party hopping, floor crossing. That is what we call defection. To give you an illustration, for example, there is a state X. The strength of the legislative assembly in this state is 100. Any political party, if it has to form the government, what is the majority required? 51. Let's say political party A gets 55 seats. Political party B gets 45 seats. Which political party is forming the government? A, because it has the majority. I am also part of A. I am also an MLA. I thought they will make me the chief minister, but they made you the chief minister. I'm sulking now. I'm not even made a minister. So what I will do, me, along with some of my colleagues who were also expecting ministerial positions, now what we do, we defect. We change the party. We cross the floor. And let's say 10 of these MLAs jump to party B. Now party B has 55 seats. Party A is reduced to 45. Now who is forming the government? B is forming the government. And this is like a musical chair. Sometimes you are part of this government, sometimes you shift to another political party. Now all of this is leading to one thing, and that is what? Instability. Instability in the government. So when I know that I am a part of a political party which has won the election, but now I will be entirely focused on keeping my flock together. Because I know at any point in time, some of these MLAs will jump the party, will join another political party, and now that political party will form the government. That means the stability of the government is under question. And this party hopping, crossing the floor, instability led to the fall of more than 50 state governments since the commencement of the constitution in 1950. And this had to stop. Not only because it leads to instability of the government, but it also violates voters' preference. Maybe people of my constituency voted for me, not because of who I am or how I look, but because I represent a political party called the BJP. I represent a political party called the Congress. So basically, people may have voted for my political party, not for me as an individual. And once I'm elected, if I join another political party, I'm violating the trust that people reposed in me. I'm violating the preference of my people. This had to end. But the curious case is of Gayalal. In 1967, elections were held for the first time in the state of Haryana. Because Haryana was carved out from Punjab, for the first time assembly elections were held in Haryana, and one independent candidate, Gayalal, got elected. Independent candidate in the sense, I contest elections. Either I contest elections on party ticket or on my own independently, which means I approached the BJP. Can you give me the ticket to contest elections from Amethi constituency in Uttar Pradesh? They gave ticket to Srimati Irani. I went to Congress. They gave ticket to Rahul Gandhi. Now where do I go? Samajwadi Party says we have some dealings with Congress. We want our cadres, our people to vote for Rahul Baba. So we will not give you the ticket. In fact, we are not contesting elections. I decide to contest elections on my own independently, independent of any political party. And once I get elected, if I defeat both of them, I become the independent member of the Lok Sabha, independent of any political party. Gayalal contested elections as an independent and he changed his party 3 times in 15 days. First, as an independent, he joined the Congress. Then from Congress, he joined the United Front. Then from United Front, he came back to Congress. One politician, he brought Gayalal to Chandigarh to face the media once he had joined their political party. And the press asked the question, whose side is Gayalal on? Because Gayalal is sometimes here, sometimes there. So we don't know on which side is Gayalal now. The politician said, Gaya Ram is now Aya Ram. Ram, a politician. He had left, now he has come back. So Aya Ram, Gaya Ram was the phrase given to these defections. I got the ticket, won the election, became the member, but now I am leaving, joining another political party. And this is like a musical chair which continues here and there. So defection was given this phrase, Aya Ram, Gaya Ram. You have come, joined a political party, after the election, joined another political party. Aya Ram, Gaya Ram. A decade later, in 1979, same state, Haryana, Bhajan Lal, along with all his members, joined Indira Gandhi's Congress. This is political immorality because you're violating the preferences of the voters as well. And this had to end. And for that, Rajiv Gandhi was the Prime Minister. 52nd Constitutional Amendment Act was passed. The year was 1985. 10th schedule was added to the Constitution. And this 10th schedule is known as the Anti-Defection Law, which means a law which will prevent these defections, which will prevent these party hoppings, floor crossing, which will ensure that stability of the government is intact so that the government can focus on governance rather than keeping their flock together. This was the need to bring in anti-defection law in 1985. To make this a tougher law, it was placed in the constitution so that a new government cannot change it on its own, so that it requires a tougher majority to change these provisions. So this was the need to bring this law. Now we will understand what are the provisions of this law. What are the provisions of this law? Number one, a member of a house belonging to any political party shall be disqualified for being the member of that house if he voluntarily gives up his membership of such political party. I am part of the BJP. BJP gave me the ticket. I contested the election. I won the election. Now I am member of a house, but I belong to a political party. I'm not an independent member. I belong to a political party. If I voluntarily resign from my party, I will be disqualified under anti-defection law. That's provision number one. That means if a member of a house can be either Lok Sabha or Rajya Sabha, Legislative Assembly or Legislative Council. That means this anti-defection law is applicable to Parliament as well, state legislatures as well. If a member of a house belonging to any political party voluntarily resigns from that party, you will be disqualified. Or if he votes or abstains from voting contrary to any direction issued by that political party. That means if you are violating 3-line whip, I am part of the Congress. Congress gave me the ticket. I contested the election. Now I am a member of a house belonging to the Congress party. Whether I am MLA or an MLC, MP of Rajya Sabha, Lok Sabha, I am the member of a house belonging to a political party. Now this political party has issued a 3-line whip. What is that 3-line whip? That recently there was a vote of no confidence against the Prime Minister. You have to vote in favor of that no confidence motion. If you decide to vote against that no confidence motion, or if you decide to abstain, because the direction is clear, you have to vote in favor of this no confidence motion. If you do anything which is contrary to this directive, what is contrary to this directive? If you vote against this no confidence motion, if you are abstaining from voting, you will be disqualified under anti-defection law. But there is an exception. What is the exception? I am Rahul Gandhi. I belong to the Congress. I am a member of a house belonging to a political party. I am a member of Lok Sabha. And a no confidence motion was introduced by the Congress against the Prime Minister. Directive has been issued to me, a 3-line whip has been issued to me that you have to vote in favor of this no confidence motion. But I could not understand this. I voted against this no confidence motion. I thought voting against it means voting against Mr. Modi. I am against Mr. Modi. That is my job. But the directive was clear. You have to vote in favor of this no confidence motion. Because if you vote in favor of this no confidence motion, it gets passed by simple majority. It means Lok Sabha has resolved that we do not have the confidence in the Prime Minister. Prime Minister has to resign. But I could not understand this. I voted against this no confidence motion because I will do anything which is against Mr. Modi. I thought this is against Mr. Modi, I will vote, which means I did not understand this. Should I be disqualified then? Rahul Gandhi is asked, what have you done? I said, I'm sorry, I could not understand. I thought this is against favor. Since I am always against Mr. Modi, I thought this is also against. So what do I do now? The political party will have 15 days to condone this violation. The political party will write to the speaker that, yes, we know Mr. Rahul Gandhi has violated the 3-line whip, but what do I tell you? He doesn't understand. But we can't tell you that. But we condone this activity, we condone this violation, no action should be taken against him. That means even if a member of a house belonging to a political party violates this directive, but if the political party within 15 days decide that no action should be taken against him, you will not be disqualified. But after the expiry of 15 days, you will be disqualified under anti-defection law. That means two provisions applicable to a member of a house belonging to a political party. If you resign from that political party, that too voluntarily. And what is that meaning? I will discuss slightly later. If you voluntarily resign from that party, you will be disqualified. If you violate the whip issued by the political party, you will be disqualified. But even if you violate, the political party has 15 days to accept, to condone your violation. And if it accepts, no action will be taken against you, even if you have violated the whip. But after the expiry of 15 days, if the political party has not condoned your violation, you will be disqualified under the provisions of the 10th schedule of the Constitution. An elected member of a house who has been elected as such otherwise than as a candidate set up by any political party. That means, who is this elected member? Independent member. That means I am a member of a house, whether Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council. But I was not given ticket by any political party. I am an independent candidate. I won the election. After the election, I am now part of the house. But I do not belong to any political party. What are the provisions related to me? I cannot join any political party after my election. If I join any political party after my election, I will be disqualified from the house. That means I am an independent member of a house because I do not belong to any political party. After my election, if I am the member of a house, if I join any political party, I will be disqualified. I will be disqualified under anti-defection law. But sir, I have a question. What is the question? Sir, we have seen in our state independent members, they also become ministers. I have seen at the central level independent members, they are also ministers. How is that possible? Why are they not disqualified under anti-defection law? Right now, for example, at the central level, we have members of the BJP part of the government. Do we or do we not? We have Mr. Amit Shah, who is part of the BJP, is also a minister. Mr. S. J. Shankar, who is part of the BJP, also a minister. Same goes the case with Ms. Smriti Irani as well. That means BJP members are part of government. They are part of ministries. Similarly, there are other political parties also who are part of the government. For example, previously, we had Harsimran Kaur Badal. She was from the Akali Dal, but she was also food processing minister. So why Harsimran Kaur Badal was not disqualified? Because she was part of the government. She is a member of a parliament belonging to a political party, but she is joining the government. She is not joining another political party. If you join another political party, you will be disqualified. She is joining the government, which means she will not be disqualified. Similarly, we have the uncle of Chirag Paswan, part of the Lok Jan Shakti party, but he is a minister. If he joins BJP, he will be disqualified. But if he joins the government, he will not be disqualified because it is like a coalition government. We have Miss Anupriya Patel. She is not part of the BJP, but she is part of the government. If as a member of a parliament belonging to their political party, if she joins BJP, then she will be disqualified. So this independent member also, if he joins a political party, will be disqualified. But if he joins the government, he will not be disqualified. Clear? So a member of a house belonging to a political party, if you join another political party, voluntarily resign from your party, you will be disqualified. If you violate the whip issued by the political party, you will be disqualified. If an independent member joins a political party after the election, you will be disqualified. And the third one is a nominated member. Who is a nominated member? Nominated member of the Rajya Sabha. Mr. Ranjan Gogoi, who was previously the Chief Justice of India, is now a nominated member of the Rajya Sabha. as a nominated member of the Rajya Sabha, once you are nominated to Rajya Sabha, can you join any political party? Yes, but within 6 months. I am nominated today to Rajya Sabha. I have 6 months to decide whether I should join a political party or not. If I join a political party within 6 months of my nomination, I will not be disqualified. But if I join a political party after 6 months of my nomination, I will be disqualified under anti-defection law. These are the provisions of anti-defection law. So what was the need to bring this law? We know that. What are the provisions of this law? We know that. Let's come to the other interesting part. Disqualification on ground of defection not to apply in case of merger. What is that merger? Let's say there is a political party A. It has got 30 MLAs or 30 MPs. If one amongst them decides to join party B, what will happen to this member? Will be disqualified, because if you voluntarily resign from your party, join another political party, you will be disqualified. But what if 2/3 of these MLAs decide to merge with this political party B? These 2/3 MLAs will not be disqualified. But listen to me carefully. Previously, till 2003, there was something known as 1/3 split. What is this 1/3 split? If there are 30 members of a political party, for example, the BJP, they are part of Lok Sabha. Clear? If 1/3 of them split, that means if these 10 MLAs split from BJP, join Congress, these 1/10 MLAs, 1/3 MLAs will not be disqualified. Why? Because there is a split in the political party. In Lok Sabha, there are 30 MPs belonging to the BJP. If 1/3 of them decide to split from the BJP, join another political party, these 1/3 MLAs will not be disqualified. But in 91st Amendment 2003, this 1/3 split was deleted. Mr. Vajpayee was the Prime Minister. 91st Constitutional Amendment Act was passed. The year was 2003. This 1/3 split was deleted. That means now, even if there is a split in the political party, even if 1/3 MLAs decide to get away, they will be disqualified. But disqualification will not exist on the ground of merger. And what is this merger? Listen to me carefully. Till recently, it was thought that if at the, let's say in Gujarat, for example, there is a legislative assembly in Gujarat. In Legislative Assembly of Gujarat, for example, the Congress has 30 MLAs. It was thought that if the 2/3 of these MLAs resign from the Congress, join the BJP, then anti-defection law will not apply, because these 2/3 MLAs, they have decided to merge with the BJP. But has Congress merged with the BJP? No. There is Congress political party in all the states in India. There is Congress as a political party present in Lok Sabha and Rajya Sabha as well. So Congress as a political party has not merged with the BJP. It is the MLAs of a political party in one house which have decided to merge with the BJP. But that is not merger, that is defection. Merger would be if, for example, there was Janata Parivar. What is this Janata Parivar? In 1977, various opposition leaders decided to come together and form a political party called Janata Party. Morarji Desai became the Prime Minister of India. But it was a short-lived exercise. The government fell, collapsed. And then this Janata Party split. Janata Dal Secular, Janata Dal United, Janata Dal A, Rashtriya Janata Dal, various other political parties split from this Janata Party. There was also one political party, the only political party which left was of Subramaniam Swamy. He said, I am the Janata Party. He had only one member. But the point is, if tomorrow, for example, JDU, which is of Nitish Kumar, and RJD, the party of Lalu Yadav, if these two political parties decide to merge, what will happen to their members in Lok Sabha, in Rajya Sabha, in Legislative Assembly, in Legislative Council? That is what this clause is talking about. If RJD and the JDU, these two political parties, decide to merge with each other, what will happen to their MLAs, MPs? If two-thirds of their MLAs, if two-thirds of their members agree with this merger, then no action will be taken against them. That means the merger should be of political parties. If, for example, Congress MLAs, two-thirds of them in Gujarat Legislative Assembly, decide to join the BJP, they will be disqualified. They should be disqualified because it is defection. It is not merger. If the political parties would have merged, what will happen to their MLAs, MPs? Let's suppose for a while that JDU merges with RJD so that JDU as a political entity does not exist. Now the only entity which exists is the RJD. What will happen to JDU MLAs, MPs? Because now they will be part of the RJD because JDU as a political entity does not exist. What will happen to their MLAs, to their MPs? They will not be disqualified if two-thirds of them agree to this merger. So it is not that two-thirds MLAs of a political party in a state, if they decide to merge with another political party, it will not be merger, it would be defection. They should be, must be disqualified under anti-defection law. Because if this is acceptable, it is basically split in a political party. But split was done away with in 2003. Split would lead to disqualification. There has been split in Shiv Sena, it will lead to disqualification. There has been split in NCP, there will be disqualification. But whether that law is implemented correctly or incorrectly, that is the question that remains. Otherwise, they should be disqualified. Because what are the provisions of this law we understood? There is an exception. There used to be an exception that if there is a split in a political party, and what is that split? If one-third members, they defect, one-third members, they join another political party, they should not be disqualified. But now this condition does not exist because it has been deleted, repealed by 91st Constitutional Amendment Act. But what remains is a merger. Disqualification on the ground of defection not to apply in case the two political parties decide to merge with each other. What if Congress, for example, tomorrow decides to merge TMC as well as NCP with itself? Because after Mamta Didi, she was part of the Congress. Sharad Pawar, he was part of the Congress. But in 1998, when Sonia Gandhi was elected as the president of the Congress party, it was not acceptable to Sharad Pawar. Sharad Pawar said, how can a woman of foreign origin become the president of the Indian National Congress? Sharad Pawar, P.S. Sangma, Anwar Ali, then Mamta Didi, they also left and they created their own political parties. Now, if tomorrow Congress says TMC will merge with it, NCP will merge with this, that means NCP members, NCP MLAs and MPs, TMC MPs and MLAs, what will happen to them? Because they have merged with Congress. They will not be disqualified if 2/3 of their MLAs agree with this. That means merger will only take place if at least 2/3 of their members in parliament and legislature agree to this merger. Sir, if only 2/3 agree and 1/3 do not, what will happen to those 1/3? They will be treated as a separate group. These 2/3 will be treated as part of the Congress. These 2/3 will be treated as part of the RJD. The remaining who don't agree, they will be treated as a separate group because they have not agreed with this merger. But 2/3 should agree, then they will not be disqualified. Something else. There is another exception. I am Om Birla. I'm part of the BJP. BJP gave me the ticket, Lok Sabha ticket, to contest from Kota in Rajasthan. I contested elections. I won the election. Now I am the member of a Lok Sabha belonging to BJP, belonging to a political party, member of a house belonging to a political party. But now I also contested election to the post of the speaker. As the speaker, I should also appear to the people that I am impartial. Although I am from the BJP, but it should appear that I am not supporting the BJP inside Lok Sabha because I am now the custodian of Lok Sabha. I am like the class monitor of Lok Sabha. I may resign from BJP. But a member of a house belonging to a political party, if he voluntarily resigns, will be disqualified under anti-defection law? Yes, but there is an exception. If you are a speaker, if you are elected as a speaker, whether Speaker of Legislative Assembly or Lok Sabha, whether Chairperson of Legislative Council, Deputy Chairperson of Legislative Council, Deputy Chairperson of Rajya Sabha, because Chairperson of Rajya Sabha cannot be disqualified because he is not the member of the House. After your election as the presiding officer, if you resign from your political party, you will not be disqualified because you want to appear impartial to the entire country. Mr. Om Birla has not resigned from BJP. He's still part of the BJP. But if he would have resigned from the BJP, would he have been disqualified? No, because he has resigned from BJP after his election as the speaker. But what if you are elected as the speaker, but after 2 years you resign or you have been removed? You have to join the political party again. I have to join the same political party which gave me the ticket. If I join any other political party, then I will be disqualified under anti-defection law. Which means it is not obligatory on part of the speaker to resign from your political party after your election. But if you decide to resign from your political party, you will not be disqualified, although you have voluntarily resigned. But it is because you have been elected as the speaker or deputy speaker or chairperson or deputy chairperson, deputy chairperson of Legislative Council, deputy chairperson of Rajya Sabha, speaker, deputy speaker of Lok Sabha and the Legislative Assembly. If you have been elected to these posts and after your election you decide to resign from your political party, you will not be disqualified. But if you join any other political party, you will be disqualified. After your term is over, or after you resign, or after you have been removed as the speaker, you have to join the same political party again. If you join any other political party, you will be disqualified. Something else. Who will take this decision that one member should be disqualified for violating anti-defection law? Who will take this decision? This decision shall be taken by the speaker. Speaker of Legislative Assembly, Speaker of Lok Sabha, this decision will be taken by the chairperson of Rajya Sabha Legislative Council. That means if an MLA, the question arises whether this MLA should be disqualified or not for violating anti-defection law, who will take this decision? Speaker. If it is the member of the Lok Sabha, who will take this decision? Speaker. If he is the member of the Legislative Council, who will take that decision? Chairperson of Legislative Council. If a member of the Rajya Sabha is subject to disqualification, that means he should be disqualified for violating 10th schedule of the Constitution. Who will take that decision? Chairperson. And Constitution says, 10th schedule says that the decision of the Speaker shall be final and binding. If the Speaker says you are not disqualified, means you are not disqualified. It's final and binding. Binding means if I say you are not disqualified, you are not disqualified. Final says after that you cannot go to anywhere else to challenge my decision, because my decision is the final decision. But what if Speaker himself is subject to disqualification? I am Mr. Om Birla. I was given ticket by the BJP, became the member of the Lok Sabha, belonging to the BJP. I became now the Speaker, and after the Speaker's election, I joined the Congress. BJP will cry, disqualify, disqualify, disqualify. I am the Speaker. I'll say, I will not disqualify myself. That would be violation of principles of natural justice. You cannot be the judge in your own case. If the Speaker is subject to disqualification, then who will take that decision? Provided that where the question has arisen is as to whether the chairman or the Speaker of a house has become subject to such disqualification, the question shall be referred for the decision of such member of the house as the house may elect in this behalf. If Mr. Om Birla is to be disqualified, Om Birla cannot take this decision because that would be violation of the principles of the natural justice. In this case, Lok Sabha will elect one person from amongst itself. And that one person's job would be just one. You decide whether Om Birla should be disqualified or not. Otherwise, the Speaker will decide. The chairman of the Rajya Sabha or the Legislative Council will decide whether disqualification under anti-defection law will happen or not. And this decision of the Speaker shall be final and binding. This law was challenged in the Supreme Court. The year was 1992 when the judgment was given. Kyoto Holohan versus Zachilhood, 1992. What Supreme Court said? Judicial review is part of the basic structure of the Constitution. When you say the decision will be taken by the Speaker and that decision shall be binding and final, this is not acceptable to us, because there has to be judicial review. There has to be check on the power of the Speaker, whether he or she has exercised that power rightly or wrongly, fairly or unfairly. We have to ensure that judicial review is part of the basic structure. So this provision of your law, where you say the decision of the Speaker shall be final and binding, it is not constitutional, because there has to be judicial review. The question was something else as well. The question was, my lord, whip. A member of a house belonging to a political party has to abide by the whip of that political party. It goes against freedom of speech. It goes against the privilege that is available to parliamentarians as individuals. As individuals, yes, we are given ticket by the political party, but we have to represent our people as well. How can we represent them if we are bound by the whip of the political party? Constitution gives me a privilege. I can say whatever I have to say. I can vote whatever I have to vote. And no action can be taken against me in any court of law. That is the privilege that I have. And now this law is saying if you vote against the whip, you will be disqualified. I have the absolute freedom to say whatever I want to say, to vote whatever and whichever way I want to vote inside the parliament. How can I be disqualified? Court said, come here. Said, what? What is mentioned as part of your privilege? No action can be taken if I say anything inside the house and if I vote in any which way inside the house. But where this action cannot be taken? As member of the parliament, I can say whatever I have to say, I can vote in whichever way, and no action can be taken against me. Where? In any court of law. That means we are not punishing you. The high courts, the Supreme Court, the court of law will not punish you for whatever you say, for whatever vote you give. We are not punishing you. But your own parliament is disqualifying you. That is not punishment. So this anti-defection law is not violating your privileges. Because come here, what? If you use any unparliamentary language inside the parliament, that means you're saying something. Are you not suspended from parliament? Yes, we are. If you throw chairs at each other, microphone at each other, you are taken out by the marshals. Are you not sent back? Said yes. But we are not taking those actions. Court of law is not involved there, is not interfering there. Your own house has made rules. Your own house has made a law to disqualify you. This is not unconstitutional. What is unconstitutional is if speaker's decision is final. That would take away judicial review, which is part of the basic structure of the Constitution. So even if you are disqualified, you come to us, we will see whether that disqualification was genuine, legitimate or not. Okay, sir, forget about privileges. How can you say whip is binding on me? It will reduce me to taking only the position of my political party. I may have a point of view which is contrary to the point of view of my political party. And I'm not allowed to have that contrary point of view because of anti-defection law. Because the whip is binding on me. So where is my freedom to do whatever I want to do inside the parliament? Court said, come here. Said, what? Let's say the political party wants to implement its election manifesto. Okay. Or a political party wants to implement its ideology. Okay. Why do you think this political party will not enforce it on you? So, but they should not. Why should they not? Because you took ticket from them. You should have considered this at the time of seeking the ticket. Once you took the ticket from them to contest the election, you know and you knew that this is the ideology of that political party. This is the manifesto of that political party. And to implement its manifesto, to implement its ideology, if the political party is forcing you to vote in favor of their agenda, you have to do that. Otherwise, just resign and contest elections again. Don't be part of that political party. But once you have been given ticket by the political party, on that ticket you got elected, you have to abide by their directions. So anti-defection law is not unconstitutional. But the only unconstitutionality is when you say the power of the speaker shall be binding and final, which would snatch judicial review, which is part of the basic structure. Something else. Even if you had defected, for example, there is BJP and there is Indian National Congress. This member of a house has decided to resign from the Congress and join the BJP. Will this member be disqualified? Yes. And he was disqualified after 1985. But even then, what BJP government will do will appoint this disqualified defector as the chairman of a public sector undertaking. as the chairman of a statutory body, as the chairman of a constitutional body. Let's say this member is me. BJP is telling me, come this side. I said, I want to, but I am member of a house belonging to the Congress. If I join you, which means I'm voluntarily resigning from my party, I will be disqualified. So why should I lose my MLA seat or an MP seat? I will have nothing. So don't worry, come this side. We will make you chairperson of National Commission for Minorities. Really? I am resigning now. Because I am part of Congress. Congress is in opposition. I will get nothing here. Here, at least, I will get the chairperson of a National Commission for Minorities, or National Commission for SCs, National Commission for STs, or I will be appointed to a board. I will be appointed to any other body where I will get the money, I'll get the salary. So for that, I am resigning from the Congress. Thanks to Atal Bihari Vajpayee, Constitution was amended again, 91st Constitutional Amendment Act. It debars a defector from holding any remunerative political post for the remaining tenure of the legislature unless he is re-elected. What does that mean? My term is for 5 years. After 2 years, I resigned from Congress, joined the BJP. Can I contest elections again? Yes. If I contest election again, I win the election again, then no problem. I am the member of a house because I have got re-elected to the house. But if I am not re-elected, or if I don't contest the election again, for the remaining part of that legislature, I am a defector. For these 3 years, I cannot be appointed to any post for which the salary is paid from the government money, from the public revenue. All these become remunerative political posts. That means a defector cannot be appointed to any remunerative political post for the period of defection, because you're disqualified for the next 3 years. If you contest election again, you can win the election again, you are re-elected, then you can be appointed anywhere. You can be appointed as a minister as well. But if you're not re-elected, you will not be holding any remunerative political post. Who can complain? In Odisha, elections were held. Biju Janata Dal of Naveen Patnaik won the election. But 4 MLAs belonging to NCP, Nationalist Congress Party of Sharad Pawar, also got elected. 4 MLAs got elected. After their election, these 4 MLAs joined BJD, Biju Janata Dal. The head of the NCP political party in Odisha filed a complaint before the speaker, saying, Speaker, we have 4 MLAs belonging to my party, NCP. They have joined Biju Janata Dal. Please disqualify them. Now something will come on your mind. But sir, 4 MLAs, all 4 of them joined the BJD. That means they should not be disqualified, because if 2/3 MLAs defect, they join another political party, they should not be disqualified. But please listen to me carefully. That should have been merger. If NCP would have merged with BJD, then they would not have been disqualified. NCP and BJD did not merge. So even if all these 4 MLAs decide to join BJD, they should be disqualified because there is no merger. It should have been a merger of political parties. This NCP president, Mr. Utkal Keshri Parida, he files a complaint before the speaker. Please take action against these 4 MLAs. They should be disqualified. Speaker said, I will not accept your complaint. Said, why? Because you don't have locus standi. Said, what is that locus standi? Because we have rules. What are these rules? Only a member can complain. Which means all the members of the Odisha Legislative Assembly, if one of them complains to the speaker, that one of our colleagues or four of our colleagues should be disqualified under anti-defection law, I will take action. Because the rule says only a member has the locus standi to complain. I said, this is cheating. All other members are from the Biju Janata Dal. We had 4 members from the opposition. They have now joined you. So how will they complain against themselves? I have the right to complain. I said, no, you can't, because the rules are against it. Only a member can complain. Mr. Utkal Keshri Parida approached the Supreme Court. The case came to be known as Speaker Odisha Legislative Assembly versus Utkal Keshri Parida 2013. Supreme Court said any voter has the locus standi. These rules, which mandate that only if the member of a house can complain to the speaker under anti-defection law, this is unconstitutional. Because you have to be fair. Fairness has to be in the rules. Any member can complain. That means tomorrow you, me, we can complain to the Speaker of Maharashtra Legislative Assembly that Mr. Ajit Pawar has defected, he should be disqualified. And the Speaker has to accept my complaint. Previously it was only the member can complain. Now it is any voter can complain. Any voter has the locus standi. But the point is, I told you, a member of a political party belonging to a house can be disqualified if he voluntarily resigns from that political party. What is this voluntary resignation? Does voluntary resignation mean I submit a written resignation letter and give it to the speaker saying I have resigned from the BJP, then I will be disqualified? That means, is a formal resignation letter necessary? Or should it be that my conduct outside the house will be judged to check whether I have defected or not? What does that mean? Sharad Yadav, Ali Anwar, both were the members of the Rajya Sabha. Both belong to JDU. Both belong to the JDU. But JDU then was part of the government in Bihar along with Congress and Lalu Prasad Yadav's RJD. After some time, Nitish Kumar ditched Congress as well as the Lalu Prasad Yadav and joined hands with Mr. Modi and became the Chief Minister of Bihar again. But this time with the support of the BJP. Which means Nitish Kumar is not joining the BJP. Nitish Kumar's political party is now having an alliance with the BJP, and together they are forming a coalition government. They're forming the government. That is not under anti-defection law. Because it may not be possible to have majority for any political party in the Lok Sabha or in the Legislative Assembly. Then 2 or 3 political parties will have to come together, not merge with each other, come together to form the government. But political parties will remain separate. Sharad Yadav, Ali Anwar, they said, we don't agree with this decision of Nitish Kumar to join hands with the BJP. And now Sharad Yadav and Ali Anwar, still as Rajya Sabha members, still belonging to the JDU, they are participating in the rallies of the opposition. They're attending the meetings of the Lalu Prasad and Congress party. They are criticizing their own political party. Their political party is asking them, please come, let's attend this meeting. They're not attending these meetings. They're not attending the political party's meetings, but they're attending the meetings of opposition political party. JDU filed an appeal filed a complaint before the chairperson of Rajya Sabha. Mr. Venkaiah Naidu, why do I come? You come here. I am the vice president. Sorry, I am coming to you. Sir, we have a complaint against, sir, 2 JDU MLA. But JDU is part of our government. But sir, these are rebel JDU MPs. They don't want to be associated with the BJP. Okay, so what do you want me to do? Sir, please disqualify them. But have they submitted any resignation letter? No. Then how can I disqualify? Because a member of a house belonging to a political party can be disqualified by the chairperson only if you have voluntarily resigned from your political party. But okay, they don't support us. Are you sure? Yes, sir, they don't support us. They support opposition. Congress, sir, Rahul Gandhi, disqualified. Sharad Yadav, Ali Anwar, disqualified. How is this possible? Because Sharad Yadav, Ali Anwar, they have not submitted formal resignation letter. So they have not voluntarily resigned from their political party. So when they have not formally resigned, voluntarily resigned, how can they be disqualified on the grounds of anti-defection law? But it is right. Because a member of a house may not have voluntarily resigned from the political party, may not have submitted formal resignation from that political party, but the conduct of this member is such that we can assume that you have voluntarily resigned from your political party. How can we assume? You don't participate in the meetings. You participate in the meetings of the opposition. You take rallies in favor of the opposition. You criticize your own political party, which means your conduct outside the house is such that we can assume that you have voluntarily resigned from your political party. You will be disqualified under anti-defection law. A person may voluntarily give up his membership of the original political party even though he did not tender his resignation. Even in absence of a formal resignation from membership, an inference can be drawn from the conduct of this member that he has voluntarily given up his membership of the political party to which he belonged. Who said this? Supreme Court. In how many cases? Multiple cases. Ravi Naik versus Union of India. G. Vishwanathan versus the Speaker of Tamil Nadu Legislative Assembly 1996. And the most famous case, Rajendra Singh Rana versus Swami Prasad Maurya 2007. Supreme Court has said, voluntary resignation does not mean that you have to submit a formal resignation. Then you can be disqualified. But if your conduct is such that we can draw an inference that you have resigned from your party, you should be disqualified, even without a formal resignation letter, anti-defection law. But then something else. There are issues with 10th schedule of the Constitution. And because of these issues, we say anti-defection law breeds defection. It was meant to control defection. It has increased defection because there are loopholes. Anti-defection law is not working fairly. Why is it not working? Because number one, there is no time period. The Speaker shall have to take a decision whether a member of a house belonging to a political party should be disqualified or not. But in how many minutes, how many hours, how many days, how many weeks, how many decades, how many centuries, how many millennia, not mentioned. When it is not mentioned, the Speaker sits on these decisions. How Speaker sits on these decisions? I'll give you one example. Telangana. Mr. T. Srinivas Yadav, he was from TDP, Telugu Desam Party of Chandrababu Naidu. Contested the election from the Sanat Nagar constituency in Telangana. Won the election. That means now he is the member of a house, which is Legislative Assembly, belonging to the TDP. TRS came to power, which is now BRS. Then it was TRS, Telangana Rashtriya Samiti. K. Chandrasekhar Rao became the Chief Minister. T. Srinivas Yadav now joins TRS. TDP filed a complaint before the Speaker. The dear Speaker, please disqualify T. Srinivas Yadav. Okay, I have received your complaint. No action was taken. T. Srinivas Yadav was now appointed as a member of Council of Ministers. He was appointed as the Minister for Commercial Taxes and Cinematography. Who appointed him? Governor. On the recommendations of Chief Minister. Because governor can appoint only that person as the minister who is recommended by the council, by the Chief Minister. So there are three constitutional functionaries who are complicit, who are guilty of violating anti-defection law. Speaker, by not disqualifying T. Srinivas Yadav, because this is a classic case of defection. If this is not defection, then I don't understand what is defection. A member of the TDP belonging to Legislative Assembly resigns from TDP, joins Congress, joins the TRS. How is this not disqualification? Speaker was told, why are you not disqualifying? Said, he has not resigned from the TDP. Said, but he has joined your ministry. But he has not resigned from the TDP. When he has not resigned, how can I take an action against him? And despite the fact that he is a defector, Chief Minister recommending him to the governor, governor knowing that he is a defector, governor appointing him, three constitutional functionaries are complicit. And the problem is there is no time limit. Matter went to the Telangana. Then it was a common high court, Andhra and Telangana high court. The high court said, we are helpless at the pre-decisional stage. High Court, please take a decision. T. Srinivas Yadav should be disqualified, please, for the sake of democracy, for the sake of anti-defection law. What do we do? Said, what? Disqualify him? No, that's something that we can't do. Separation of powers, my dear. Said, yeah, but what are you saying? See, we have the power of judicial review. That means once the speaker takes a decision, then we can review whether that decision was correct or incorrect. So if the speaker says, I will not disqualify, then you come to us. If the speaker says he is not disqualified, or if the speaker says he is disqualified, then you come to us, then we can review. That is what judicial review is. But we are helpless, my dear, when the speaker is yet to decide. When the matter is still in a pre-decisional stage, we can't help you because there is no time limit. This happened in 2014, and till 2018, he was a minister. And till now, even till then, he was not disqualified because there is no time limit within which the speaker has to take any decision. That is the biggest problem. Another bigger problem is Karnataka, which is similar problem to what we faced in Madhya Pradesh. What is the problem? Now, resignation is a new loophole in anti-defection law. What is this loophole? For example, we have 250 MLAs in a state X. For example, to form the government, what do we need? 126 MLAs. Clear? BJP has 110 MLAs. Congress has 100 MLAs. Another political party, JDS, has 40 MLAs. Who will form the government? Nobody. Why? Because no political party has the majority. Now, Congress and the JDS, they decide to come together to form a coalition government. They have 140 MLAs, which is more than the majority required. They are now forming the government. When they are forming the government, after some time, after a few months, after a year, some of these MLAs are given cash. And I will not tell you who is giving this cash. That's understood. Cash or threat. You have done corruption previously. If you don't resign now, we will open that case Enforcement Directorate, CBI, money laundering case, you are gone. Now, whether that is true or not, some of these MLAs belonging to the Congress and the JDS, they now decide to resign. How many have now resigned? Let's say 30 MLAs have resigned. Will these 30 MLAs be disqualified? Yes. Because a member of a house belonging to a political party, if you voluntarily resign, you will be disqualified. You're disqualified. But what will they gain by resigning? And what will BJP gain by forcing them to resign? BJP can be replaced with Congress tomorrow if Congress comes to power. All of them would do the same thing. What would they gain by forcing them to resign? What would they gain? If there were 250 MLAs, 30 MLAs have resigned, which basically means now the strength of the Legislative Assembly is only 220. Or to put it mathematically correct, 31 MLAs have resigned. Now the strength of the Legislative Assembly becomes 219. This is the strength. Any political party to form the government has to get half of these seats, which means the BJP has 110 MLAs. BJP forms the government. So resignation is like a loophole. There is a political party or a group of political parties forming the government. You force their MLAs to resign so that the number of strength of the Legislative Assembly reduces and another political party is able to form the government. Same happened in Madhya Pradesh as well. Kamal Nath's Congress had 110 or 112 MLAs. BJP had 104 MLAs. There was very little difference between the two. What you basically did, you forced 22 MLAs of the Congress to resign so that Congress is now minus 22. Legislative Assembly is also minus 22, which means the simple majority mark which was required has now come down, which means the BJP is able to form the government. Bulldozer Mama is the Chief Minister. Matter went to the Karnataka High Court. Karnataka High Court was told that please do one thing. Said what? This anti-defection law is being used, overused, misused now, abused now. Please do something. Said what? These 31 MLAs, they should be disqualified for the remainder of the term. The remainder of the term means if these 31 MLAs, their term was 5 years and they resigned after 1 year. Right now, my lord, what is happening? After they resign or after they are disqualified, they can contest elections again. Because these 31 MLAs who have resigned, they resigned from 31 seats. These seats are now vacant. Within 6 months, Election Commission of India will have to organize elections in these seats. Please do one thing. Don't let them contest this election. Let them be disqualified for the remainder of the term. That means for the next 4 years, they should not be allowed to contest elections. Karnataka High Court said, you're absolutely right. This is how we can make anti-defection law perfect, or at least very strong law. So that if today I'm resigning, I see no loss because I'm resigning. But at the same time, what happens? There is a vacancy in my seat. I can now contest election again, but this time on the ticket of the BJP. If I win, I will become the minister under the BJP government. So there is a lot of incentive for me to resign. But if we make it that you resign, you will not contest election for the remainder of the term. It will force you not to resign, because what if I don't get elected? What if for the next 3 years, 4 years, someone else is elected from my constituency? He does or she does the good work. People will forget me. What will I do? I am left with nothing. But this High Court order was challenged before the Supreme Court. Supreme Court said no. You will be disqualified, but you can contest the election again. But sir, why? This is making anti-defection law a stronger law. So, yeah, the law can be strong, but after all, it is the will of the people. If these MLAs were part of the Congress, after their election, they resigned from Congress, joined the BJP. It's for the people to decide whether to vote for them again or not. Who are you and me to decide? Because after all, it is democracy. 17 MLAs of the Congress and the JDS who resigned from their political parties when Mr. Yediyurappa became the Chief Minister of Karnataka. Out of these 17 MLAs, when all of them contested election again, 16 of them were re-elected by the people. So blame the people, not the law. People favor the defectors. So right now the position is, even if you are disqualified, you are not disqualified for the remainder of the term. You are disqualified now. Once the election is announced, you can contest the election again. If you're elected again, you can become a minister. So resignation is now a loophole. The better solution would be a defector should be disqualified from contesting the election for the remainder of the term. This would be a strong disincentive for the people not to defect. And this is a problem that we faced in Karnataka. This is the problem that we faced in Madhya Pradesh as well. Something else happened. Manipur. What happened in Manipur? One Congress MLA, Mr. T. Shyam Kumar, resigned from Congress, joined the BJP. He was made a minister, forests minister. Speaker was asked, please disqualify him. Speaker did not take any action. Matter went to the Supreme Court. Supreme Court said, we have to give time to the speaker. Speaker, please take decision. Speaker said, yes, I will. Next hearing, speaker is asking for more time. Supreme Court says, what do we do? Kapil Sibal, who is representing the Congress, he says, don't give him time. Court says, but we have to give time because we believe in fairness. You are given more time. Please take the decision. Another hearing, I need more time. Supreme Court was furious. Justice Rohinton Fali Nariman is one of the judge. He says, I will use Article 142. What is Article 142? Supreme Court can issue any order so as to give complete justice. Any order to give complete justice. Supreme Court said, T. Shyam Kumar, you are removed as a minister. T. Shyam Kumar is asking, under what provisions? Under Article 142 of the Constitution to give complete justice. Who has the power to appoint a minister? Governor. Who has the power to remove a minister? Governor, on the advice of the chief minister. But this time Supreme Court is using its power and says, T. Shyam Kumar, you are removed as a minister. It can do anything to give complete justice. T. Shyam Kumar, don't you dare enter the Legislative Assembly till the speaker takes a decision. And speaker, you have 3 weeks to decide. Take the decision. After this reprimand, the Speaker of Manipur Legislative Assembly took the decision and disqualified T. Shyam Kumar for violating anti-defection law. But in this case, Supreme Court made a very strong observation. Supreme Court said a time has come when Parliament should have a rethink on whether disqualification petitions ought to be entrusted to a speaker as a quasi-judicial authority when such a speaker continues to belong to a particular political party. Right now, the problem is there is no time limit within which the speaker takes a decision. But the speaker is partial. Let's accept this. The speaker is sitting like a tribunal. It's a quasi-judicial body because the speaker has to take a decision whether you should be disqualified or not. So the speaker is a quasi-judicial body here, taking a decision, but the speaker belongs to a political party. Now, how will I take a fair decision? If I am the chairperson of the Rajya Sabha, belonging to the BJP, if the defector is against the BJP, immediate disqualification. If the defector supports the BJP, sit on this matter, don't take any action. Why? Because there is no time limit. So what is the solution? Define the entire procedure and set a reasonable time limit. Let it be 1 month, 2 months, 3 months. Let it be 3 months. But within 3 months, you have to take the decision. Or Speaker has a lot of work to do. Because that's what Speaker is saying right now. I have a lot of work to do. There is so much on my plate that I don't have time to look into these disqualification petitions. We agree with you. That's why we want to snatch this power from you. And we want to give this power to Election Commission of India. Whether you can be disqualified on the grounds of change in the nature of citizenship, adjudged insolvent, mental unsoundness, office of profit, who takes a decision? President in case of parliament, governor in matters related to the state legislature. But they cannot take decisions on their own. They have to take decisions on the advice of the Election Commission of India. That means Election Commission of India report is binding on the president and the governor. In anti-defection law matters also, let's absolve Speaker of this role and responsibility and entrust this responsibility to the Election Commission of India. Let Election Commission of India also handle disqualifications under anti-defection law. But something else has happened. Where? In Maharashtra. It's a long story in Maharashtra, but I will just give you the crux. Elections are held in 2019. No political party gets the majority. BJP emerges as the single largest party, but Shiv Sena plus the Nationalist Congress Party plus the Congress Party decide to come together and form the government. Not acceptable to the BJP. Mumbai is the financial capital of India. Political parties raise money from corporates as well, from businessmen as well. And which better place than Mumbai or Maharashtra? For whatever reason, some members of the Shiv Sena, they defect, they split from Shiv Sena, led by Mr. Shinde, Eknath Shinde. And the other group is by Shri Uddhav Thackeray. If you understand this case, you will understand the NCP case as well, where there is a split in NCP as well. One part led by Ajit Pawar, the other part led by Sharad Pawar. And we don't have to waste time in getting to the root of these problems. We just have to understand the bigger picture. There were close to 56 MLAs belonging to the Shiv Sena. And more than 2/3 of them decide to back Eknath Shinde. And now Eknath Shinde is the leader. And Eknath Shinde joined hands with the BJP, formed the government. Eknath Shinde is now the chief minister. If the law would be applied fairly, Mr. Eknath Shinde will be disqualified. Why? Because for them to come out, split is no longer a requirement. Prior to 1993, if there was a split in a political party, even if 1/3 of them would move away, no action could have been taken against them. But now there is no such provision as split. Split is not allowed. Even if there is a split, you should be disqualified. Merger is allowed. But Eknath Shinde's faction of Shiv Sena did not merge with the BJP. They can't merge with the BJP. Because merger is not only of, there is a political party, and in political party there is organization wing, there is legislature wing. I have a political party, Congress, for example. I have an organization wing. That means there is president of the Congress party, there are vice presidents of the Congress party, general secretaries of the Congress party, office bearers of the Congress party, district heads, district presidents, zonal presidents, block president. This is the organization. But not all members of the Congress political party are part of the parliament or part of the house, because they should get the support of the people. Only 52 of them got the support. They are part of the Lok Sabha. And those members of the Congress party who are part of a house, they are part of the legislature wing. So for political parties to merge, organizations have to merge. Then this merger should be supported by the legislature wing as well. And 2/3 members should support this merger. Shiv Sena is of Mr. Uddhav Thackeray. Uddhav Thackeray gave ticket to various leaders. They contested elections on the ticket of the Shiv Sena to be in Legislative Assembly. And then whip. Who will issue this whip? That is the question that Supreme Court asked. Will this whip be issued by the leader of the legislature party or the leader of the organization? For example, we have 50 MPs in Lok Sabha belonging to Congress. Clear? And the Congress has appointed Mr. Gaurav Gogoi as the whip of the Congress. Now, Mr. Gaurav Gogoi, can he issue this whip on his own, or he has to consult Mallikarjun Kharge, the Congress president? He has to consult the Congress president, because this whip is by political party. Because political party has to tell its MPs how to vote, because they gave you the ticket. Supreme Court said, yes, this whip should be issued by the organization, not by the leader of the legislature party. So, Mr. Speaker of Maharashtra Legislative Assembly, please take the decision and decide on the disqualification of these MLAs. Because later on, Election Commission of India also got involved. Shiv Sena has a political symbol, bow and the arrow. And that is the symbol through which people know Shiv Sena. For example, you may not know the candidate of a political party, but you know the symbol of this political party is lotus or hand. You will vote for that. Symbol is very important brand value for a candidate or for a political party. Now, if in Shiv Sena there is a split, Eknath Shinde claims, I am the Shiv Sena. Uddhav Thackeray claims, I am the Shiv Sena. Now, when two claims are there for a political party, Election Commission of India gets involved and decides which is the real Shiv Sena. Will the real Shiv Sena please stand up? And for that, Election Commission of India decides on the basis of which faction has the majority in organization as well as the legislature. So those members who support Uddhav Thackeray, please stand up in the organization. Those who support Eknath Shinde, please stand up, give us the details. If in organization, we have Mr. Uddhav Thackeray who gets the majority of the support. In the legislature, we have Mr. Shinde who gets the support. Then there is a tie. We can't take the decision. But Election Commission had to take the decision. Election Commission said, Eknath Shinde is the real Shiv Sena. Why? Because the legislature party supports Eknath Shinde. Because in Lok Sabha, majority of Shiv Sena MPs support Shinde. In Rajya Sabha, majority of the MPs support Mr. Shinde. In Legislative Assembly also, majority MLAs support Mr. Shinde. But what about organization? We don't have the updated details of the constitution of Shiv Sena. That is why we may not get to know in the organization who supports whom. So Mr. Shinde is the real Shiv Sena. But when they defected, at that time, who was the real Shiv Sena? Mr. Uddhav Thackeray's Shiv Sena. That means at that time, the whip was binding on them. Which means the speaker should have disqualified Mr. Shinde and all the members who support Mr. Shinde. But who is the speaker? Mr. Narvekar. He belongs to BJP. BJP is part of the government. He is not taking any action. Matter goes to the court again. Sir, please ask Speaker to take the decision. Speaker, please take decision. What are you doing? Sir, I have a lot of work to do. Then there is Nagpur session of the legislature. Then, sir, there is split in Sharad Pawar's party as well. That also I have to look. I have so much work to do. These theatrics not in front of us. Mr. Narvekar, you have time till December 31, 2023. Decide. And if Maharashtra Speaker really decides by 31st of December 2023, then Mr. Eknath Shinde will be disqualified. All the members who supported him will be disqualified. Because when they defected, which was the real political party, Uddhav Thackeray's political party, they had issued a whip which they did not abide by, they will be disqualified. Whether they are supported by 2/3 members or 1/3 doesn't matter. Because they would have been saved only if they would have merged with the BJP. But since they did not merge, they defected, they should be disqualified. That is anti-defection law. Any questions? Let me know. Sir, if the speaker is removed, if that means he's also removed from MP seat. If you are removed as the speaker, you are removed only as a speaker. If you are disqualified, that means you are gone as a member as well as speaker as well. And what happened there? Where? So from now, 1/3 to 2/3 can join any political party, and it's only replaced the word from split to merger. No, now even 2/3 cannot join a political party. This 2/3 will have to merge with a political party. Merger would be not only of the legislature wing, but also the organization wing. Can you please explain Eknath Shinde case? What was I explaining? My case? Is the same which happened in AIA-DMK split in Tamil Nadu. Yes, the two leaves, the symbol of AIA-DMK. There were two claimants. One was Mr. Palaniswamy. The other was Mr. Paneer Selvam. Both claimed that we are the real AIA-DMK. Ultimately, they had a compromise and both retained the two-leaf symbol of the AIA-DMK. Then after some time, Mr. Paneer Selvam was expelled. Problem solved. If the speaker chooses not to take any action, he will be sentenced for contempt of court. Has speaker taken the decision in Maharashtra? My dear, what did I say? Supreme Court yesterday, which you will read in today's newspaper, asked the Maharashtra speaker, Mr. Rahul Narvekar, take the decision by December 31st, which means he has not taken the decision yet. Why Supreme Court didn't question on split? Why? This is right. There should be no split. No split should be allowed. Because people voted for you basis on your political party. Now, if you join another political party, what is this? This is a musical chair? Resign and then contest again. Sir, why Uddhav Thackeray not appointed as CM? My dear, CM is appointed by the MLAs, whoever has the majority. Majority right now is that of BJP, one faction of Shiv Sena, one faction of NCP, and they have decided to have Mr. Shinde as the chief minister, Mr. Devendra Fadnavis and Ajit Pawar as two deputy chief ministers. Sir, why Congress MLAs were not disqualified after joining the BJP? Where? If it was in Karnataka, if it was in Madhya Pradesh, they resigned. When you resign, you don't need to be disqualified. Listen to me carefully. If I am a member of Lok Sabha and as a member of Lok Sabha, I resign from Congress and join the BJP, I will be disqualified from Lok Sabha. But what if I am a member of Congress belonging to Lok Sabha, but I resign from Lok Sabha? I resign from Lok Sabha. Now I am not a member of any house. Now I join the BJP. If you want to disqualify me from where? I am not a member of any house. So why should you disqualify me? How can you disqualify me? So there is a difference. Logical step is, if you want to save yourself from disqualification, you are from BJP, but you want to join the Congress. If you are member of a house belonging to BJP, if you want to join Congress, if I join like this, I will be disqualified. Disqualified from? Because I was the member of parliament. I will be disqualified. Best step would be, I am from Congress, I want to join BJP, I am member of Lok Sabha. I will first tell the speaker, sir, this is my resignation. I want to resign from Lok Sabha. Now that I have resigned from Lok Sabha, I am not the member of Lok Sabha, I joined the other political party. Now, will I be disqualified? No. Why? Because I am not a member of a house. Jyotiraditya Scindia, why was he not disqualified? Because he was not member of the parliament. 22 of his supporters as MLAs, they resigned as MLAs, then joined the BJP. Jyotiraditya Scindia, he was from Congress, simply joined the BJP. Should he have been disqualified? Yes, if he was the member of legislature, but he was not the member of the legislature. In fact, he lost the Lok Sabha elections from his constituency. Got the difference? Sir, if Eknath Shinde will be disqualified in December, then elections will be held. No need for elections. Why? Ask yourself this question. If, let's say, one political party, or let's name it, this is everybody's truth now. If BJP and the Mr. Shinde's faction had the majority, clear? Why would they engineer a split in NCP to split Ajit Pawar from his uncle and ask this faction of NCP to join the government? Because you know that under anti-defection law, Mr. Eknath Shinde would be disqualified. Then you can't form the government because you won't have the majority. Then you need other support of NCP rebel MLAs. Now you have the majority, you run the government. But sir, NCP MLAs will also be disqualified by that logic. Yes, but it will take time. Sir, how much time? Till 2024. Then at that time there will already be election because the term of the Legislative Assembly will be over. Tomorrow we will be starting discussion on center-state relations. What is the difference between merger of political parties and coalition government? There is a coalition government, for example, in Bihar. There is JDU, there is Congress, there is RJD. Together they have formed the government. But individually they have their own political parties. Political parties coming together to form the government. That's a coalition government. Merger is if JDU, RJD, they decide to merge with each other. That means they want to merge their political parties so that at the end of the day, there is only one political entity which remains, whether RJD or JDU. That is merger. Sir, if Mr. Om Birla, after his tenure as MP, why can't he change his political party? He has the choice to join any political party. There is no stoppage on that. Mr. Om Birla, after the election is over, after the term of Lok Sabha is over, he can contest elections again. But what we are saying is, once a speaker, always a speaker. This should be the practice. Because the speaker is acting in a partisan way. What is the solution? In UK, MP is elected as the speaker. Listen to me carefully. In Britain, they follow a practice called once a speaker, always a speaker. In Britain, elections happened. I got elected. I am now the member of House of Commons, right, which is the lower house of British Parliament. I belong to a political party, let's say the Labour Party. I am a member of House of Commons belonging to the Labour Party, but now I also want to become the speaker. I am elected by the members of House of Commons by the majority, by the simple majority. I am now the speaker. Now, once I am elected as the speaker, I will resign from my political party. That means now I am no longer the member of the Labour Party. I am the Speaker of the House of Commons. Which means I will not be dependent upon my political party for support. I will not do them a favor because now I will be impartial to the entire House, all the members. But after 5 years are over, I have to go back to my constituency to get elected. Who will give me the ticket? If I did not support my political party, they won't give me the ticket. If I don't support the opposition, they won't give me the ticket. So that means to get the ticket after 5 years, I have to support some political parties, which may mean that I will be partial. I may not be impartial. But in Britain, once you are elected as the speaker, let's say the previous speaker resigns, or the previous speaker is dead, or the previous speaker is removed. Now I am elected as the speaker. I will resign from my political party. And now for this entire term, I will be the speaker. Next year, next 5 years, I have to contest elections. From my constituency, other political parties will not set up any candidate. That means if I am Mr. Om Birla, I got elected to Lok Sabha from Kota. If it was not India, if it was Britain, I am Mr. Om Birla, I got elected to Lok Sabha from Kota. Now I'm elected as the speaker. I will resign from BJP because I am now the speaker. And now as the speaker, I will not favor any political party, neither Congress nor BJP. Why? Because I don't need anything from them. But do you need, after 5 years, you want to contest election from Kota again? If you're not elected, which means you cannot be the speaker. Once a speaker, always a speaker. Means Om Birla, once his term is over, he has to contest election from Kota again. Neither the Congress nor the BJP nor any other political party will file a candidate against me, will give ticket to any other candidate against me. That means I will get re-elected from Kota unopposed. Nobody opposes me. Why? Because this will give me security. That if I am the speaker of the Lok Sabha, I don't have to fear anybody. Now I am the speaker, I will remain the speaker forever. After 5 years, I will contest elections. I will be re-elected. I know I will be re-elected because no candidate will come against me. Which means now I will be partial because my life is not dependent upon the support that I get from political parties. I will be now impartial. Can this happen in India? Should this happen in India? Argument number one is yes, because that will make speaker an impartial institution. But the other argument is no. Why? Because then I won't represent my constituency better. Because I will take it for granted that people will have to elect me because there is no other candidate. I will be unopposed. This will deprive the people of my constituency their democratic right to choose the representative of their choice. But for the sake of democracy, should this be allowed? Should this be entertained? Perhaps yes, because speaker is the most important institution. And we have discussed what speaker can do under anti-defection law. What speaker can do in suspending members of the opposition. What the speaker can do in how the money bills are passed. What the speaker can do in suspending members. What the speaker can do in allowing or disallowing members to speak or vote. What the speaker can do. For that sake, we need an impartial man or a woman as the speaker. And for that, once a speaker, always a speaker. This practice, which is followed in Britain, should be followed in India. Then why by-elections were not held in MP after minister resigned? Either you have the complete knowledge or don't assume things. When you're saying why by-elections were not held, how do you know by-elections were not held? By-elections were held. In all those 22 seats, by-elections were held. 9 of them were won by the Congress candidates again. Sir, I have a question. If one nation, one election need to happen, what steps? We'll discuss that in elections. Okay, so let's leave it here. Let's meet tomorrow, 6 o'clock in the morning, and we will discuss center-state relations. See you tomorrow. Till then, have a great time. Bye-bye. All the best.